This is the case of the State of Ohio versus Dwayne Gabbard, case number 25 CR 42744. Present before the court is Mr. Gabbard, represented by Mr. Elter. We have Mr. Harris in the prosecutor's office. We are here today for the purposes of a bond hearing. Just to update everybody on the status, Mr. Gabbard's bond was revoked because we received a presumptive positive test for both methamphetamines and amphetamines on the August 13th drug test. Bond was revoked. It was sent out to the lab. Grandpa Small called the lab this morning and said that they have it and we should have a result within the next 24 to 48 hours. If it comes back as a false positive, I'm going to get Mr. Gabbard back on supervision. If it's a true positive, I'm going to hold him until the trial.
And then if that's the case, Your Honor, we're going to try to reschedule the trial for the 15th.
I could do it on the 15th.
All right, we might look into that. Do you want to set it for trial, or do you want to work on resolving?
Last time you sent me to a program was important, and they didn't send me up there knowing that I didn't have enough time, so I had to stay there a couple months to get me the
Okay. Would you do a program now?
No.
Okay.
I wouldn't have time. I ain't got an education. I can't read and write, so it's kind of.
If that's the case, you'd go to jail then, right? You would go to jail. If you don't go to a program, you plead guilty, you're going to go to jail.
Yeah,
right?
yeah. No,
Is that what you'd rather do? Or would you like to come back?
Mr. Luxon, can you see if this Hinkle
What's
is?
that?
Can you see if this Hinkle is in
You could get it over
the
right now.
attorney lounge?
You get 7 months. I'll take it right now.
I think the judge said 9 months.
Well, he sent me there last time, and I had to spend an extra couple months, so
Right.
he get me 8 months and I'll run.
Your Honor, Mr. Gabbard has indicated he would be willing to enter a plea with an idea that he probably understands he'd serve 8 months in prison. However, I told him that the court might be inclined for more. Is it a situation where we could enter a plea today and set it for a sentencing? Say next week?
If he wants to enter a plea, I'm good with that. I'll set it for sentencing. The last time I sent him to prison, it was for 9 months. It doesn't seem like the water is going to be much shallower than that. But that was 8 years ago. So it might be that there's something in the PSI that tells me that that's not the right sentence. Mr. Gabbard needs to go to a drug treatment program. I know he won't. So that's what we're stuck with.
Well, if you entered a guilty plea, what the court would do is set it for sentencing to figure out how much time you would be sentenced to prison.
Yeah.
Do you want to do that? Start the process of getting it over with today?
Yeah.
Okay. All right. Sure. All right. Now, so this is plea. It's an F5, which is good.
This a couple of times before, but I want to make sure that we have a clean record in each case. How old are you?
How old am I?
Yes.
5.
How far did you go in school?
8th grade.
Are you able to read and write English?
Huh?
Are you able to read and write English?
A little bit.
Are you under the influence of drugs or alcohol?
Right now, no.
Are you taking any medications?
No.
Are you a United States citizen?
Yeah.
We've had some discussions about your case. I want to send you to a drug treatment program really bad, but you won't go. So if you change your mind between now and the time that we come back for sentencing, I would be more than happy to send you to a treatment program. But if you want to continue to maintain the position that you have always maintained, that you will not go to a treatment program, then the only thing that I can do is send you to prison. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No.
I have a document entitled Change of Plea and Entry. On the second page, there is a signature above the line defendant. Is that your signature?
Yeah.
Did you review this with Mr. Elter before you signed it?
Huh?
Did you review this with Mr. Elter before you signed it?
Yeah.
Did he read to you any portions that you were not able to read on your own?
What?
Was there any part of the document that you did not understand or were unable to read? Because the court then can go over that with you.
Yeah, I understand.
All right, you're going to be entering a plea of guilty to one count of aggravated possession of drugs. This is a fifth-degree felony. It's punishable by up to 12 months in prison and a $2,500 fine. It also carries with it an optional period of post-release control of up to 2 years. Your rights really haven't changed that much since we went over them back in 2016. You still have the right to make the state of Ohio prove that you're guilty of this unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at that trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir.
Mr. Harris?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, that on or about December 31st of 2024, South Lebanon, Warren County, Ohio, the defendant, Dwayne Gabbard, possessed methamphetamine. This was after a traffic stop. It was sent to the lab and confirmed at 2.55 grams, which is a Schedule II drug.
Anything on those facts, Mr. Elter?
No, Your Honor.
Mr. Gabbard, did you hear those facts? Did you hear the facts that Mr. Harris just read into the record?
Yeah.
Do you admit that those facts are true?
Yeah.
Do you understand the rights that you're giving up by entering a plea of guilty?
Yeah.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. We're not going to go into the matter of the sentence today. I'm going to go ahead and vacate our trial for September. We're going to do a level 2 pre-sentence investigation, also an evaluation to determine whether or not you're appropriate for a community-based corrections facility. We'll come back here in about 6 weeks for the sentence. Anything else, Mr. Elter?
No, thank you, Your Honor.
All right. And you need to talk to Mr. Phillips some more?
Yes, Your Honor.
All right.
6 weeks, if there's in between, you get credit for that.
Car, are you ready?
State of Ohio versus Savannah Harp, case number 21 CR 37813. Present before the court is Ms. Harp, represented by Ms. Carr. We have Mr. Harris in the prosecutor's office and Officer Torek from probation. We're here today for sentencing. Has everybody had the opportunity to review the PSI?
Yes, Your Honor.
Any reason not to go forward with sentence today?
No, Your Honor.
Mr. Harris, on behalf of the state,
Your Honor, the courts had the benefit of hearing this case, albeit it was several years ago. There was a co-defendant who was found guilty after a bench trial. We would ask that the sanctions against Ms. Harp be of the same magnitude. I think in Chambers, the only difference was Ms. Collins had served an additional 3 days, other than the 2 days that Ms. Harp has credit for at this point. We are requesting for community service and that she not possess or reside with any companion animals, as well as any other sanctions from the court.
Mr. Tark, anything from probation? Ms. Carr?
Your Honor, by all accounts, Ms. Harp has been doing well on pretrial supervision up to this point. My understanding, this is her first criminal offense, in her lifetime. She is very regrettable. She's very upset about the actions that she and her co-defendant took that resulted in this terrible situation. As you know, she's here to take accountability. We do appreciate the state taking this to a misdemeanor. I have discussed the sentencing proposal that you gave him back in chambers. She does understand that and is looking forward to complying with the court up to the best of her ability so she can put everything behind herself.
What do you want to tell me, Ms. Harp, if anything?
Nothing. I'm very grateful that you guys jumped them.
All right, court's going to impose a community control sanction. That means that you're going to be on basic probation for a period of 3 years.
Okay.
I'm going to order that you be subject to the standard rules of probation. I don't want to load you up with a bunch of drug testing or drug treatment. I want you to do 80 hours of community service. You are not to own any or be in the same household as any companion animals or pets. And I'm going to give you credit for the 5 days you've already done. I'm not going to impose a fine. I am going to impose the costs. I do not want to put a lot of work into you, Ms. Harp. Behave yourself, do your community service, get you off probation hopefully in a year or so.
Yes, sir.
Anything else to do? Anything I forgot?
Just so we're clear, I believe she's only got 2 days of jail.
Oh, I'm sorry, two days of jail time credit. Yeah, that was Ms. Collins had the 5 days.
So it'd be 2 days credit for 2.
Yes, 2 days jail time credit. If you do violate the terms of your supervision, I could sentence you up to the maximum penalty in this case, which is 180 days in jail. Good luck to you.
Thank you.
Thank you, Governor.
All right, and we are still waiting for Ms. Phillips' attorney to arrive. Deputy, I don't know if, you need a minute, Ms. Hinkle? All right, this is the case of the State of Ohio versus Lisa Phillips. Case numbers 25 CR 42725 and 25 CR 42777. Present before the court is Ms. Phillips, represented by Ms. Hinkle. We have Mr. Harris in the prosecutor's office. We're here today for an arraignment. Has Ms. Phillips received a copy of the indictment? No? Okay.
We've got two different cases. I think she was here on the, let's see, the earlier case number was 725. So the new case was 777. Here's a copy of the new indictment. Does she have either one? No. Okay.
I just printed the 725 indictment.
Okay, I just gave the 42777.
Right? Is that what that is? All right, how is it that we're going forward today, Ms. Hinkle?
At this time, I haven't had a chance to actually speak with Miss Phillips yet.
Okay.
She,
Why don't you take a couple of minutes and talk for a minute, and then we'll do the arraignment. Do we still have the Holder and Kettering?
No, it's done.
It's over with?
I
Okay.
came back last night.
All right, so the plan is, so I don't know how much you're up on this, Ms. Hinkle. So we had a bond hearing back in June, and we had a Holder in Cuyahoga County, which has been resolved. You went there and are back. What's the status of that case?
I pleaded out.
Okay.
I didn't come back.
And she had a Holder in Kettering, which is now gone. So the plan is to get her over to Genesis while this case is pending. So if we go ahead and do the arraignment, meaning that she's going to waive formal reading, 24-hour period, enter not guilty plea, we'll set it for a pretrial probably in about 30 days, get her over to Genesis and get back here to see where we're at. So take a minute, talk to her, review the indictment with her. We'll be calling in a couple of minutes.
Okay, thank you, Your Honor. The indictment and just ask for this to be set out for another pretrial.
All right, Ms. Phillips, you were charged in the 725 case with one count of receiving stolen property. This is a fifth-degree felony, punishable by up to 12 months in prison. There's also a drug paraphernalia charge attached to that. In the 777 case, you're charged with one count of receiving stolen property, one count of aggravated possession of drugs, one count of aggravated possession of, one count of possession of cocaine, and a misdemeanor instruments charges. The most serious of those is also a fifth-degree felony, punishable by up to 12 months in prison. I am going to grant you an OR bond. That's an agreement between you and I that you're going to come to court when I tell you to. It's going to be a condition of your OR bond that you enter into and successfully complete the Genesis program. Plus, we need to find a place for you after Genesis, assuming that this doesn't resolve before then.
May I say something?
Sure.
When I was in Cleveland, I had a lot of, what's the word? A lot more hope up there. I think I'm going to go north when I get done with everything. There is transitional housing that can help me get on my feet, change my people, places, and things. I really want to do that. So I'm looking at going to Akron.
Okay.
I don't know if maybe if I find something, I'll let you guys know and maybe transfer whatever I'll be doing. But that is my goal, is to go to Akron and start a new place there.
Okay. Let's go ahead and set this for a pretrial scheduling conference in about 3 weeks. So she'll still be in Genesis by then, and then we can look at a post-Genesis plan if, in fact, you're guilty of some or all of these things. We'll figure that out. Ms. Kuroko will get you a date today. So we'll get you over to the Genesis program, and I'll see you in a few weeks.
She's on pretrial supervision at this point.
Yes.
Correct.
Yeah, I actually think I already did
Did
a
it once, yeah.
bail order, maybe.
I got it, yeah, 2 weeks ago.
Nope. Oh, yeah, I did. All right. On the commitment, it is released to a representative of the Genesis program. Okay. All right.
Thank
Thank
you,
you,
Your Honor.
Your Honor.
And then let me give you one.
Julie.
I think he's reason.
Sorry, it took me. I know you were on top of that. I was.
Okay, are you aware of this? He filed a motion.
He just told me that.
Sir,
He just told me that.
Day before yesterday. All right, anything you want to summarize on this, Mr. Dusler?
No, sir, other than what I've already got in there, I think he agrees to everything.
Are you able to hire a lawyer?
I've been working on it, but I just haven't been able to because of my student situation.
About your what?
My student situation.
What about it?
I'm just doing school right now, so I haven't been able to do it.
I paid my way through school. College, doctorate, master's degree. I paid my way. I worked and paid. Yeah, I mean, if I can do it, I'm not special.
I'm working.
You can do it.
Yes, sir. I am working on.
Well, the taxpayers are paying this,
Yes, sir.
and they don't find it amusing to be paying for, well, indictments from other people. It's not a free ride. I mean, it's just you're accused of a crime and you got to fix it, and everybody's got to figure it out on their own on how that's done in a responsible way. Well, problem you have here is were you retained or okay? See, I'm not going to put my public defenders in a situation where they feel like they are threatened. You can represent yourself. Well, that's what he says.
No, I just asked for the.
What happened? Can you summarize?
Well, on the most recent event last week, he and his father showed up in my office. Yes, very demanding, threatening my staff.
In what way did they threaten your staff?
With expletives. And
You're cursing?
no, I didn't.
What, he's making this up,
I promise
sir?
I didn't cuss. Sir.
He's making this up?
I barely said anything when I got there. I didn't make it.
Was he cursing?
Primarily the father.
The father was, wait a second, sir. I've known this man for 40 years. When I speak, you be quiet.
Yes, sir.
Because two people can't speak over each other.
Yes.
She's got to take everything.
Yeah.
All right. So you got something on video?
Yes.
I want to see that.
Can I come? May I approach?
Yeah. Yeah, because this is, all right, good. Well, this is, a problem, and
There we
public defenders aren't going to.
Mr. Dusler.
Hold on, I'm speaking. The public defenders aren't going to be put in harm's way,
No,
especially.
sir.
Hold on. I'm going to point to you when we get to speak, okay? Because that's the way it's going to work, because you keep interrupting. The public defenders, the people who are paid by the people, I mean, he's not getting paid extra. He's not getting paid retained attorney's fees like some lawyers who charge a lot of money, because we're talking about a first degree felony, life imprisonment. So what's that worth? It's worth people paying money for help to get them help them out in their situation. But it doesn't do anybody any good who needs the help, unless you want to represent yourself, which is always catastrophic. To threaten the people who are there as your lifeline. And these are appointed, the taxpayers are paying him and my other public defenders for people who are unable to pay, which I find a little odd, since I worked the day I turned 16. I've worked from the day I turned 16. I've worked my whole life. From the day I turned 80 cents an hour at 3 a.m. If I can do it, anybody can do it. It's just a matter of having the will and the effort. But when you are charged with a crime, you've got some responsibility of helping yourself see through this. All right. Let me look at this here. All right. We call now 25 CR 243, the state of Texas versus Brandon Chase Owens. That's you. Present with Mr. Dusner, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here, and we proceed in a summary fashion?
Yes, sir.
In summary, this indictment alleges that on or about August 19th, 2024, in Jefferson County, Texas, you committed the offense of theft. And it is a state jail felony because paragraph 2 goes on to allege that you have at least 3 theft convictions out of county court of Jasper County in 2015, county court of law 2 of Orange County, Texas in 2016, and in September of 2022 in this court. So paragraphs 1 and 2 constitute a state jail felony. So because you have 2 or more prior theft convictions, every time if you steal a pack of gum, it's a felony. Okay. We gotta quit doing that. If convicted of a state jail felony, you face no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, sentenced to 2 years in the state jail. That confinement would be suspended. You would be put on a regular probation for 5 years. Order to pay restitution in the amount of.
It's been paid in full today.
Oh, you've already paid it?
Yes, he gave us the cashier's check this morning.
Oh, okay. Is that your and there would be terms and conditions of probation otherwise, which are normal and customary for this type of offense. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
You know, I figured out how to do this now. I put this case jacket over this, so.
Oh, your hand. Right now?
It works. If your hand touches the pad, it marks it up. But this doesn't for some reason. How do you plead to this charge, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty? And paragraph 2, those prior convictions, are those all true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to those voluntarily and because it is true?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Sure.
Understand it, discuss it with your attorney, or the contents true and correct? State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged from any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All true, so help you God.
Honestly, yes, sir. Today is the first time I've actually got to speak to him. I called office several times on voicemails. I didn't even know what the plea deal was until less than a week ago. And I left several voicemails trying to get a hold of him. You're satisfied with the plea agreement?
Do you need some additional time to consider it and talk about it?
No, I had brought paperwork showing that I went to the Social Security office because of my mental disabilities. So I'm trying to get on SSI. I can't work right now because the DA's office put in a different charge than what I had back in 22.
When he was arrested, the TRN was incorrect when he was arrested, but he wasn't convicted. Everything was correct.
Was that
All-
fixed?
Yeah.
Was there any harm done to him?
I had death threats. My grandmother's house got shot twice.
Death threats?
You have a prolific criminal history. I don't know if the
Death threats by not the DA's office.
No, I'm talking about death threats from people thinking I'm a child molester because of the charge. So they're right if I tried to apply for DoorDash as an employee, and that says, possess, promotion, lewd visual material depicting children. And that was on my record for almost 2 years. I have not been able to get a job since I was back on my record.
None of our paperwork reflects that because it was corrected at the time of the plea in 22.
No, ma'am.
No, the judgment that judge can give you in just a minute is correct. You were arrested and they messed up with.
Yeah, they messed up. Yeah, with the wrong code. So
Okay.
I've got to go to the lawyer.
That was,
to try to.
that's not us.
No.
I mean,
No, I know.
we're pretty sensitive about the accuracy. I'm looking at a judgment of conviction that I signed on September 26, 2022. This is state jail, confinement in state jail for 20 months for disclosure or promotion of intimate material. That's what the charge was.
Yes, sir. But
That's correct, right?
yeah, that's the correct one.
Okay.
I messed up in the DA's office and put in the wrong.
Yep.
That's actually not the DA's office. We don't put in the TRN.
I just need to find out who put in the code because I'm getting a lawyer for that.
Your lawyer figure it out. They'll know. Whatever civil attorney.
Yeah, I'm looking at all the records on this docket sheet and there's nothing that's reflecting what you're talking about. So whatever that that occurred before it got into us.
Yes, sir.
Well, we're pretty sensitive about that.
These are for him if you'd like copies.
Is that a copy for him?
Yes.
Okay.
I was just letting you know that was the reason I've been having trouble finding employment. Says
That's okay.
that said that on.
Fix, yeah, tell us what, if there's something we need to do to help you on this, to fix the mistake, you let me know. But accuracy is important and you don't get punished you shouldn't get punished for mistakes that need to be fixed. Okay.
But yeah, I have been seeking employment through the rehabilitation vocational program with the Texas Workforce Center. And so that they need a 30-day extension to see whether or not I qualify or not for the eligibility.
If something needs to be corrected,
It's all been, sir.
Okay. If nonetheless, if something slips through, let us know and we'll do what we can to fix it. Because they're going to, people generally rely on my word in correcting things because we're the final authority and sometimes mistakes pass on, but it gets fixed. I'm going to make the following findings: that you have pleaded guilty today voluntarily to paragraphs 1 and 2 constituting the state jail felony of theft. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I find you guilty beyond a reasonable doubt of the state jail felony in paragraphs 1 and 2 of this indictment. I'm following this agreement. You were hereby sentenced to confinement in the state jail for 2 years. That is suspended. You are placed on regular probation for 5 years. There will be terms and conditions of probation which are normal and customary for this type of offense. And one of them is theft prevention class. It's always a good one to take, and it will help you. Please follow those rules. If you fail, your probation could be revoked and you can be sentenced up to 2 years in the state jail, which nobody wants. Okay. Anything else? Please see the probation officer.
One thing, Judge, I'm a pastor, sir.
Your pastor?
My pastor for church.
What church is that?
Destiny Church in Orange.
Oh, okay.
And he's right there.
Where's he?
And he had something that he wanted to read to bring up.
You have to read now. I mean, we do a lot more to do.
Yeah. What is it, sir? What do you have?
Well, I was just here to support that he's been going through a lot of this therapy, counseling, and he's doing all things right to get things in order.
Good.
So,
Good. Everybody makes mistakes. It's how you deal with your mistakes. That's the test of character. Okay.
Yeah, I'm just here to represent the head and doing things necessary to get
Good.
things on track.
That's what we like to see. Yeah, everybody here makes serious mistakes, but it's how you deal with them. Not always do people fix it. And he sounds like he's on the road. Thanks very much for helping him.
I just need
All right, here's that. Thanks.
in the file. Okay.
Okay, Milford Kinney?
Mr. Kelly's office said that's supposed to be a dismissal of Daniel today, but his employee is not here, so I'm not sure.
All right, guys, ladies from DA's office to be dismissed because nobody's here and
It's Daniel.
I'll look it
the defendant, is the defendant here? Milford Kinney?
No notes.
I'm looking it up right now, Judge.
Ryan, I'm gonna go Ryan McGowan. Ryan McGowan? So, and of course I have two add-ons that made up for those resets. Ryan McGowan. That's you, sir?
Yes, sir.
25 CR 333. Announcement.
That belonged to attorneys no longer with our office.
Yes, I
So
understand.
I need
What are we
to,
doing today?
just need a little time to make it up for her, and I think she's got a motion for it. Did you file a motion for an investigator?
Have not filed it, but it's with Ellie for ex parte motion for funds for the investigator. So if we could have 4 weeks, I don't believe she's made you aware of it yet.
Okay.
I haven't told it yet.
Okay. 4 weeks,
Yeah.
good. Please get resetting. Thank you. Mr. McGowan, Dewan Waltrip. Forward. This is another announcement, state jail felony.
Yes.
And
We have received a amended offer this morning, Judge. If I can have 3 to 4 weeks.
3 weeks, good?
Yes.
Good.
Thank
Get
you.
resetting, please. Thank you. Okay. Kevin Hall.
He's done bad. Yeah,
Do we need him out?
we do. Hold the file.
Kevin Hall, please.
This is one I haven't.
Okay, Milford Kinney is to be dismissed. And Brandon Owens, we took care of that one already, right?
Yes. That will be.
Milford.
What's up? You got to tell you?
Milford Kinney.
You already?
Keita Brown.
I think she went to the bank to get the money order to bring to the VA, and they're gonna bring us the dismissal.
Maybe.
If she comes.
It's not there.
No, I think she had it. She had to wait for them to open, I think. Judge, this is a final, switch, you know, it's the third
I
one.
remember when that village.
Not having-
Being already fell.
Thank you for getting custody this.
The entire.
Kevin Hall.
But the state has criminal history.
I do.
Were there 3 cases?
Yeah, there is, Your Honor.
Racing again. Okay. We're to meet. No, we don't have. We don't have any of that stuff. It's gonna have to be a open conversation.
I want to have a jury charge in.
Okay.
I only look at 345 on this court today trial.
Thank you. It
Uh,
was a hung jury, yes.
That's one. I talked that we don't have to do it.
Yes, that's all of them.
Okay, I have a numeric sequence of 22-40762, illegal possession of methamphetamine, second-degree felony. The defendant has 2 prior aggravated robberies. That second degree, I guess, is enhanced to a first degree. 22-40983, unlawful possession of a firearm by a felon, third degree. And this alleges on 40983, do you have a copy of the indictment? Paragraph 1 alleges felon in possession of
I don't actually.
a firearm. Okay, and he was previously convicted of aggravated robbery in 84136. And then paragraph 2 says 84135, he had another aggravated. Okay, that's what that is. Okay. So that is a third degree felony enhanced to a second degree. Finally, aggravated robbery in 40985, first degree felony. And the two April 14th, 2003 aggravated robbery convictions are alleged. So this first degree felony is enhanced to no less than 15 or more than 99 or life imprisonment. All right. You are Kevin Michael Hall. And these were all indicted going on 3 years. But we already tried one. That was a mistrial. What was his hung jury?
It was a hung jury.
All right, go ahead.
Right, he's been in custody for 3 years, trial already on one time, but he's still been in custody. He's a resident of Beaumont, so at the time he's here all his life. We'd ask that the bonds be reduced to a reasonable amount. You can put a GPS on them and the other rules and conditions on them. But he asked that he be allowed to try to make reasonable bond. I have been retained, so I'm not here.
Well, if he's got money to retain, you ought to be able to post a bond, right?
Well, not at the amounts that you have on it, Judge.
What are they? What are they, please?
600,000.
What kind of bond can he make?
We're asking for 50,000. About 50,000 each, or 150,000 total.
What's that say?
He's got a place, I'm sorry, before I didn't want to go. He's got a place to stay, and he's got family here, so he could have GPS and other customary rules and regulations.
Your Honor, he already has 2 aggravated robberies. He picked up another aggravated robbery. After he got out of prison, he got the drug case, the felon in possession of a firearm. I don't know if you remember this case when we tried it, but it's the one where the store clerk got shot at in his store.
Last year, but
It was, yes. We tried Mr. Hall. We had a hung jury. We tried the co-defendant who was found guilty and given 32 years by the jury. The state's been ready to retry this case for the last year. He retained counsel, so it's been postponed for that, but the state has been ready the entire time.
when's the next trial setting?
That I don't know.
When's the next trial setting?
I don't have a trial setting because we moved to the court date to today for the bond hearing.
My understanding from the transcripts, Judge, that ID basically was done by a pair of sneakers.
Well, and other things, but
All right. Okay. What's the last one, King? Set it on trial docket to retry this thing as soon as possible. Number one, $50,000 on each charge. He must be home confinement. He must have a GPS device as a condition of bond.
What else do you need? Anything? Is that the bond? Home confinement is.
Yes.
That's one, so. And can he work back and forth?
Okay.
If he was to give his work schedule, I provide that to the board, of where he would be.
He has to have a GPS device and he would have to go to and from work the most direct route possible, or else his bond would be revocable.
So if I
And he
provide,
can go to the hospital if he has some medical care and go to the store to get food, the
And see me.
necessity. Those are the exceptions.
you see me,
And to meet with your attorney and get legal advice to and from the most direct route possible. Any variation, your bond will be revoked. But let's try this. Something we don't have the wherewithal to do is try and pay for the same real estate twice, but we got to get it done,
thank you, Your Honor.
even though it's impossible. We're going to try.
Maybe excuse
Get
Your
to
Honor.
it fast as we can. Yes, thank you. Corbin, please. What do we do with Brown and keep it Brown?
Judge, she's here, and that's the one we're waiting on restitution, asking for 2 months for complete restitution. You can do it.
Wasn't something to be done right now?
No, sir. We're just today resetting for a couple of months for to finish paying our restitution, so they'll dismiss.
How much is it?
It was originally 10,000. I know she's been making payments of several $100s each week.
How much is it left?
I don't know.
Does anybody know?
6,000 left. She feels like in a couple of months she can have completed.
Yeah, I've heard that before.
Well, she's been making regular.
I've done this 18 and a half years. The day it really happens, I'll jump out the window. But I hear it all the time. Everybody's got promises. How much has been paid on this so far?
About half. It was originally 10,000.
What's about half mean?
Well, 10,000 was what it was originally. She says she owes around 6 now.
Okay, 40% has been done.
It was over 10, but it's fine. But she has been making regular payments, including one this morning.
How much was this morning?
200.
Winston. Okay. How often can you make payments?
They can every Friday.
How much?
I can't put a tag on it. I don't know how many.
Like it's like tips or something you get paid?
The job right now. So I'm just DoorDash.
All right, let me, what we'll do is just come back in 6 weeks.
Since he didn't understand it, he's that
Okay.
potential 3 days. He does also have and sort of we put them all together.
Still pending.
Yes.
Okay.
I don't know.
Which is where the suspension came from. I
Well,
think.
no, the suspension I think came from the Franklin County OBI that's
Okay.
pending.
All right. So there's a warrant out of Franklin County. Do you know?
Yeah, on their docket, it says it's in order and status, so
Okay. Do we have a warrant or not?
I don't know. I would try to get a hold of Sticks and Mark tried to call downstairs.
Okay. Is that the OVI case?
Yes.
Okay. Did you miss a hearing in Franklin County?
Yeah, they never sent me, I never received the paper. Even for
Okay.
last one, I had a hearing on August 8th or something. I received the paper on August 15th.
Okay.
So I was.
Okay. So there might be a warrant in Franklin County for you for not appearing, is what she's telling me, for missing that hearing.
Is he going to jail today?
I don't have a warrant, so we can't. We're not gonna arrest him without a warrant. So.
Right.
So
So we didn't have it verified.
You'll want to go.
I had it verified last time, but it
Yeah,
wasn't here.
you'll want to go get that taken care of.
How do I do that?
Do you have an attorney on that case?
Not when I was there.
Yeah, I think.
Okay. All right. Contact your attorney.
But every time I went to the court, she never showed up.
Okay. Well, I would contact the court then, see what your bond is. You might have to pay bond. But you'll have to go into court and get that taken care of, get a new hearing date.
Okay.
Okay. I'll continue this one today for you here.
Thank you, boss.
All right.
Like, I've been on so much trouble. By the way, if you had a beard, you'd look like Lincoln.
All right. Any questions about that?
No.
Okay. Make sure you show up. Okay.
No, I will. I will.
Okay.
Have you had a seat right here?
And my birthday
Does he have the
was
warrant?
Well, we're gonna have a seat. Let's go chat.
Okay.
Need to give him a name
Okay.
and a social.
Okay. This officer's gonna check to see if you have a warrant. So. Yeah.
Pues es que yo no tengo ni idea.
No.
No.
All right, I need you to explain whether you want some time to hire an attorney or whether you want to proceed on your own behalf today. I need an
Señor,
either or.
necesito de que usted me explique, señor, si usted desea tiempo para poder contratar a un abogado o si usted desea proceder por sí mismo el día de hoy.
No, dile que procedes por ti mismo el día de hoy.
Procedo por mí mismo el día de hoy.
I would like to proceed on my own today.
All right, I hear a voice beside you. Is someone directing you and guiding you today, sir?
Bien, señor, escucho una voz que se encuentra al lado de usted. ¿Hay alguien que le esté indicando o guiando lo que tiene que hacer el día de hoy, señor?
Dile que soy tu hermano.
Es mi hermana.
She is my sister.
All right, well, is she also an attorney?
De acuerdo, ella también es una abogada.
No.
No.
All right, well, she can give you sisterly advice, but I can also give you time to get an attorney. Do you understand that?
Bueno, señor, ella le puede dar consejos como hermana, pero también le puede otorgar tiempo a usted para que pueda obtener a un abogado. ¿Usted comprende ello?
Sí.
Yes.
And again, you do not want an attorney. You want to waive your right, that is, give up your right to an attorney and proceed on your own behalf today.
Y una vez más, usted no quiere un abogado, usted quiere exonerar su derecho a un abogado y estaría procediendo por sí mismo el día de hoy. ¿Es correcto?
Sí.
Yes.
Is anyone making you give up your right to an attorney by any threats or promises?
Bien, ¿hay alguien que esté haciendo que usted renuncie a su derecho a tener un abogado por algún tipo de amenaza o promesa?
No.
No.
All right, then I will have the record reflect in the journal entry and the docket notes that you're waiving your right to an attorney. You're doing so of your own free will, and you know what you're doing.
Bien, estaría haciendo que el registro refleje en el jornal del expediente, las notas del expediente, que usted está exonerando su derecho a un abogado y que usted lo está haciendo bajo su propia voluntad y que tiene conocimiento de lo que está haciendo.
And that's what you want, sir.
A ver, espérate.
Judge, just to let you know, I did have him read and sign a Spanish waiver of counsel.
¿Está diciendo algo o no?
Señoría, simplemente para poder hacerlo, he hecho de que lea y firme en español una exoneración de cancelación.
Pregúntale, ¿tienes preguntas?
No, no.
O sea, tú ocupas un abogado porque vas a ir a corte.
Is the sister interpreting as well?
¿La hermana está interpretando para usted también?
I'm just trying to have him understand what you're trying to say, because I'm not 100% sure if he's understanding what you're fully saying. Does he really?
Stand up here.
I just trying to, is it what you're saying that he's not gonna get
Court-appointed
a lawyer?
attorney.
Yeah,
You can
attorney.
hire an attorney, but I can't give him a court-appointed attorney because there isn't any threat of jail time.
Bueno, sí, en realidad yo no le puedo brindar a él ningún abogado que sea señalado por el tribunal debido a de que no hay amenaza de que él pase tiempo en la cárcel.
Okay, entonces, como quien dice, él está negando que vaya un abogado con él puede hacer todo solo. Es a lo que me refiero.
So, well, he is rejecting to be represented by an attorney, and he can do it. He can do all of this by himself. That's what I mean.
I can either set this hearing over to another date and allow him to go out and hire an attorney on his own, or he can present on his own behalf today and enter his plea today without an attorney.
Okay, and if he doesn't have an attorney, what happens? I mean, what happens?
If he waives his attorney, I will ask him how he pleads to the charges, and either set it for trial or accept his plea and proceed to sentencing, depending upon how he pleads.
Okay. Sí, o sea, sí, básicamente si él tiene un abogado, el abogado hablaría por él, y si no tiene abogado, él hablaría por él mismo ahorita mismo, ¿correcto?
Basically, if he has an attorney, the attorney is going to speak on his behalf, but if he doesn't have one, he is going to speak by himself. Is that right?
That is right.
Es correcto, señora.
¿Sí estás entendiendo?
Sí.
¿Qué quieres hacer? ¿Quieres que un abogado te represente o quieres de una vez ahorita?
No, pues de una vez.
Okay. He
Okay,
said sorry, go ahead.
all right, which way do you want to go, Mr. Maldonado?
Bien, señor, ¿en qué forma desea proceder, señor Maldonado?
With or without an attorney?
¿Con o sin abogado?
Sin abogado.
Without an attorney.
All right. Mr. Maldonado, are you understanding what I'm saying with the aid of the interpreter, Jose Vigo?
Señor Maldonado, ¿usted comprende lo que estoy diciendo a usted con la ayuda del intérprete José Vigo?
Sí.
Yes.
All right. So your sister was helping you understand more the legal concepts or the language?
Mira, su hermana le estaba ayudando a que usted comprenda los conceptos legales o el lenguaje.
Los legales.
The legal concepts.
Okay. Do you need an attorney to help you understand those, sir?
¿Usted necesita de un abogado para poder entender ello, señor?
No.
No.
I just realized that no proof of insurance charge in count 2 does carry a sentence up to 6 months, so I could appoint an attorney for that. Also, count 3 is a B misdemeanor, and I could appoint an attorney for that.
Mire, señor, me acabo de dar cuenta de que también tiene una infracción por no contar con prueba de seguro de automóvil y una infracción número 2 que también conlleva una sentencia de 6 meses, y también podría nombrar un abogado por ello, así como una infracción número 3 que vendría a ser un delito menor, y también podría nombrar a un abogado para ello.
So if you do want to apply for court-appointed attorney, we'll get you an application and you can fill it out and leave it with the deputy there.
Así que, señor, si usted quiere hacer la solicitud para un abogado que sea nombrado por el juzgado, nosotros le podemos brindar una solicitud que usted puede llenar y dejarla allí con el secretario.
Sí.
Yes.
All right, so I'm going to recess your case, let him give you a form to go fill out in another room, and let him know, or one of the deputies know, when that's complete.
Bien, en todo caso estaría haciendo una receso de su caso y le estaríamos dando un formulario para que usted pueda llenar en otra sala, y le haríamos saber a uno de los secretarios, mejor dicho, hágale saber a uno de los secretarios cuando usted ya haya completado el formulario.
And I will continue this case to the next interpreter docket, which is when, clerk? Destiny.
Your Honor, that'll be November 5th.
Bien, estaría continuando con el caso con el siguiente expediente de intérprete, que vendría a ser cuando su secretaria. Bueno, su señoría, eso sería el 5 de noviembre.
And that is at 1:30 on November 5th. It will be by Zoom.
Bueno, y esto vendría a ser a la 1:30 del día 5 de noviembre y se estaría llevando a cabo por medio de Zoom.
But if you finish that application and turn it in, we'll see if you qualify for an attorney and who that would be, sir.
Pero en el caso de que usted complete esa solicitud y la presente, nosotros estaríamos viendo si usted califica para un abogado y quién sería ese abogado, señor.
All right, so you may step aside at this time and go fill out the application.
Así que, bueno, usted debería salir en este momento y, para poder llenar esa solicitud.
Your Honor, one final matter.
Yes.
Entonces, señoría, un caso final.
Your Honor, if the court is continuing this matter to the November interpreter docket, is the court also continuing the cash bond in this matter?
The defendant will be continued on his cash bond with the added requirement that he reappear November 5th at 1:30 and that he turn in his application for attorney before he leaves today.
El acusado estaría continuando con su fianza en efectivo con el requerimiento adicional de que él va a comparecer nuevamente el día 5 de noviembre a la 1:30 y de que va a presentar su solicitud para un abogado antes de que él se retire el día de hoy.
Sí.
Yes.
All right, so you may leave the courtroom at this time, sir.
Bien, señoría, tendría que salir de la sala del juzgado en este momento, señor.
And deputy, who did you say was the other language interpreter defendant?
Secretario, que me dijo que era el otro intérprete, mejor dicho, acusado que necesitaba un intérprete de español.
It's going to be last name of Daniel, the first name of Martin something. It's listed under ours as last name David. Daniel Martin.
All right, if you'll bring him in, please.
Yes, he's coming.
Thank you.
Good morning, sir. Good morning.
We are on the record in Butler County District Court, case number 2025 TR 1259, State of Kansas versus Daniel Meraz Martin David.
Bien, nos encontramos en el registro nuevamente. Este es el Tribunal Distrital del Condado de Butler. En el caso número 2025 TR 1259, el Estado de Kansas versus el señor Daniel Morales Martínez David.
Morales, no.
Daniel Meraz Martin David.
Yeah.
Sí, Daniel Moraz Martín David.
All right, and you are Mr. David?
¿Y usted es el señor David?
Yes, el primer nombre es Martín.
Yes, but my first name is Martin.
Okay, so your first name is Martin. Is your second name Meraz?
It's David, second name.
David is the second name. What's your next name? What's your third name?
El primero es Martín, el que sigue es David y el apellido es Daniel Meraz. En México se ponen dos apellidos.
Señor, este es el intérprete. Dijo de que los apellidos serían
Daniel Meraz.
Daniel Meraz. Okay. Yes, my last name is Daniel, and the second last name is Meraz.
All right, clerk, who needs to file a document to?
On behalf of the state of Ohio, we're here hearing on ILC. At this time, based upon the circumstances of the defendant, the court is going to deny the motion for ILC. It's my understanding she's going to change her plea to guilty to the possession charge, correct?
That's right, Judge.
Correct, yeah. All right, Ms. Chapman, they're telling me you're going to change your plea to guilty to the one count of possession of a fentanyl-related compound. How old are you? How far did you go in school?
I was a nurse for 20 years.
Can you read and write? Yes? Can you say yes?
Yes.
Are you a citizen of the United States?
Yes.
Does anyone promise you how the court will sentence you, understanding that I represented to Mr. Kirby that I intend to give you a credit for your time served and cut you loose today? Anybody say anything to you other than that? Has anyone threatened you in any way to get you to plead guilty against your will? Are you satisfied with the representation you've received from Mr. Kirby? Are you currently under the influence of any drugs or alcohol? Do you take medication that interferes with your ability to understand what's going on? All right. Is this your signature on this form? Did you have a chance to read this and go over it with Mr. Kirby? And you feel like you understand what it says? All right. This says you're entering a plea of guilty to one count of possession of a fentanyl-related compound as a felony of the 5th degree. That carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. Do you understand what the maximum penalty is? Now, you are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that? You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or they are required to find you not guilty. Their verdict must be unanimous. Do you understand that? At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of the state's witnesses. Do you understand that? You have the right to call witnesses on your behalf. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. Do you understand that? You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you. Do you understand that? The burden of proof is on the prosecutor. You don't have to present any evidence or call any witnesses, and that won't be used against you. Do you understand that? The standard of proof is beyond a reasonable doubt. The standard applies to each of the essential elements of each charge from the indictment. Do you understand that? You can also waive your right to a jury trial, but maintain all the other rights and try your case to the court. The same standard would apply, proof beyond a reasonable doubt. Do you understand that? Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We're not going to have a trial. This is how you want to proceed. Mr. Harris.
Your Honor, if this matter proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment as to count one, that on or about September 10th of 2022, defendant Natasha Chapman was found in possession of fentanyl, being 0.62 grams after being arrested in Springboro, Warren County, Ohio, on an outstanding warrant.
All right, anything on those facts? Ms. Chapman, do you acknowledge that that was the truth of what happened? Yes. All right. And again, you understand all the rights you're giving up. What's your plea? All right, the court will make a finding you've made a knowing, intelligent, and voluntary waiver of your constitutional rights, and the court will accept your plea of guilty, and based upon the statement of facts, the court will make a finding of guilty. Mr. Harris, anything before I sentence her?
Your Honor, we'll defer to the court.
Mr. Kirby?
Nothing further than stated in chambers.
Ms. Chapman, is there anything you want to say? Do you have anything you want to say before I sentence you other than that? All right, the court's considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. The court will order you to serve 73 days in the Warren County Jail. The court will give you credit for the 73 days you served, and your case is terminated. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. You are subject to a discretionary period of post-release control, which is not going to apply in this case, but if you're sent to prison on this, when you're released, the adult parole authority could supervise you for up to 2 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC. Anything else?
No, yeah.
Best of luck to you, Ms. Chapman. All right, hang on. All right, this is case number 25CR42617, the state of Ohio versus Justin Meeker. Mr. Meeker is before the court with his counsel, Mr. Kirby. Ms. Tranter, on behalf of the state of Ohio, we're here for sentencing. Ms. Tranter, anything on behalf of the state?
Your Honor, this is an agreed recommended sentence. We would ask the court to adopt the sentence that is before it today. In addition, I do have Detective Schweitzer here who would like an opportunity to address the court just on behalf of Trooper Valentine, who was injured as a result of this case.
Okay. Detective Schweitzer, you want to step forward, please?
Yes, sir. I don't want to take up too much time.
Go over here, please. Right next to that red thing.
Court's time. I just wanted to say that when this took place, Mr. Meeker had an ounce of cocaine, a loaded firearm ready at hand, not even in a holster, which caused Trooper Valentine to go through the vehicle to shield from the gun. Trooper Valentine went through the vehicle, fell on his knee, cracked his kneecap completely in two. He's been off since that date, I believe 4/11, so over 4 months. He's still not back to work because of Mr. Meeker's actions. He lost his canine. Because of Mr. Meeker's actions, he will probably have problems with his leg for the rest of his life. And although it's a agreed sentence, I think that Mr. Meeker needs to know that he's affected a state trooper for the rest of his life.
Are you or your department in agreement with this agreed sentence, recommended sentence?
We are, Your Honor.
Okay, all right. Thank you, Detective.
Thank you.
Appreciate that. Anything else,
Nothing from the state, Your Honor.
Mr. Kirby?
Your Honor, my client has been engaged in treatment. I think that substance abuse played a major role in his decision-making. What happened to the trooper, there was no intention that happened. I think it was a freak incident that did happen, but my client has taken full responsibility for that. This is an agreed sentence. Judge is here present today with his parents. We'd ask the court to adopt the joint recommended sentence.
Mr. Meeker, is there anything you'd like to say before I sentence you, sir?
I am very apologetic that the officer did get hurt during this incident. I had no intentions of that whatsoever. As my lawyer, Mr. Kirby, has said, substance abuse definitely played a large part of my decisions that day. I have been seeking substance abuse help through Claremont Recovery Center. I actually graduated intensive outpatient rehab and went into just regular outpatient rehab. But I am severely sorry that the officer was injured in that incident.
Anything else, sir?
No, sir.
All right, the court has considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. The court has also considered the agreed recommended sentence of the parties and finds it to be an appropriate sentence. All right, so at this point in time, Mr. Meeker, the court is going to order you to serve a prison sentence on count one, a minimum term sentence of 3 years, a maximum term sentence of 4.5 years. On the firearm specification, the court is going to order you to serve 1 year. That by law to be served prior to and consecutive to the minimum term sentence of 3 years. The firearm is ordered to be forfeited. On count 5, the court's going to order you to serve 12 months in prison. That to be served concurrent with count 1. And on count 6, the court's going to order you to serve 6 months in the Warren County Jail. That by law to be served concurrent with count 1 and 5. The court has received and reviewed the affidavit of indigency that's been filed on behalf of Mr. Meeker, and the court finds that he's indigent for the purpose of any fines, costs, or other financial sanctions, including the mandatory fine. Do we have a jail time credit? I didn't write that down. 14 days jail time credit, right?
That's correct.
Now, you're also subject to a mandatory period of post-release control, which means upon your release from prison, the adult parole authority will supervise you for a period of up to 5 years, but not less than 2 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original minimum term sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Now, it is possible for you to earn good time credit of 5 to 15% against your minimum sentence for good behavior. The court has a right to deny your good time credit, and a hearing would be held to make that determination. Regardless of whether you receive good time credit, you will be released when you finish your minimum term, unless the Department of Corrections determines that you must remain in prison for bad conduct. We went over all of those things with you at the time of the plea. The court is not involved in that decision. If you're not released when your minimum term ends, you will serve an additional specified period of time and given a new release date, and you would serve until that date unless you are again denied release. This process could repeat itself until you are released or you finish your maximum term sentence. As I indicated, that the firearm is ordered to be forfeited. You do have a right to appeal this court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. At this time, the court's going to order you remanded into the custody of the Warren County Sheriff for transport to the Department of Corrections. Anything else?
No, Your Honor. Thank you.
Thank you all. Mr. Casey. Let me do Casey real quick. Mr. Casey, Isaiah Casey. All right, this is case number 23CR40750, the state of Ohio versus Isaiah Casey. Mr. Casey is before the court with his counsel, Mr. Kirby. Ms. Nicholson is here on behalf of the state of Ohio. We're here for a final probation violation hearing. Mr. Casey, it's always been the court's intention that the Hamilton County case get resolved before I decide what I'm going to do. Yes, because a lot of what I do is going to hinge upon what they end up doing. So it's looking like they're either going to send you to prison or send you to a CBCF. Does that sound close to what's being represented to you down there?
Yes, sir.
Okay.
Just,
when's that set for hearing?
on the 25th of this month.
Okay. What I'm going to do is I'm going to reset this until after that case, because if they send you to prison, there's really nothing else I can do but to go along with and set a sentence as well that's concurrent with that. The other thing is if they send you to River City, again, I'll probably continue on community control and order you to comply with that order. Does it make sense?
Yes, sir.
So it doesn't make any sense for me to do anything today because whatever they decide is probably going to end up controlling what happens here.
Yes, sir.
Any questions?
No, sir.
Mr. Kirby, you wish to be heard on the issue of bond?
Yes, Your Honor. It's my understanding that Mr. Casey did post bond for his Hamilton County case. We would ask this court to release Mr. Casey on bond. He does have suitable housing available to him in Hamilton County, specifically Price Hill. He would be residing with his aunt. We'd ask the court consider that.
Well, Mr. Casey, what's his jail time credit? It's like
45 days.
Mr. Casey, I'm going to deny that request because you've been found guilty in this case, right? So it's not like you're presumed innocent anymore in this case. I get it in Hamilton County why they would set a bond, but in this case, one of my options is to let you serve local time and then just to end your supervision. So that's what, in my mind, at this time, I'm kind of punishing you for violating the rules of community control. So this is part of your punishment. But this is all going to play into my decision when I bring you back in a week or so, just so you understand that, okay?
Yes.
All right, so
Thank you.
that request is denied. All right, thank you.
And then Judge, for Mr. Beebe, we're just gonna get a new date.
Right.
That works for.
How much time do you and Teresa need on that?
I don't need much time at all. I think Teresa had some.
All right, this is the case of the State of Ohio versus Brandy Brown, case number 21 CR 38009. Present before the court is Ms. Brown, right?
Yes, Your Honor.
And we have Mr. View from the prosecutor's office, Officer Sukovecki from probation. We're here today, Ms. Brown, because I've received a report that alleges that you have violated the terms of your supervision. The allegation is that you were unsuccessfully discharged from the Recovery Works program and you absconded from supervision back in December of 2021. You have the right to be represented by a lawyer in the case. If you can't afford one, I will appoint a lawyer for you. Do you want to be represented by a lawyer?
I mean, yeah, that would be preferable.
Okay.
I don't think I could represent myself very well.
Okay. Officer Sukovecki, do you know where she keeps the affidavits of indigency, where Ms. Kroko keeps those?
Nope. Do you know? I can grab them.
They're there somewhere, I think, right on top. Probably shouldn't have come in without her. There'll be no living with her after this.
Are they in this black bin? I feel like she usually walks over here. Yeah.
It's not a waiver. It would be the affidavit.
Option two. Yes. We're gonna do three of them, maybe.
Oh, here she is. Hello, Ms. Kuroko. You are indispensable. Ms. Brown wants to be appointed an attorney in the case. Who are we appointing? All right, I do find that you're indigent for the purposes of hiring a lawyer in the case. I'm going to appoint Ms. Kirby to represent you. You have her contact information there. We're also going to send her an email today that lets her know that she has been appointed. I'm going to set this for a final hearing. That's probably going to take place in about a week to 10 days. Does it make sense for me to make referrals for drug treatment facilities, Ms. Brown, or are you intent on going back to Tennessee?
Well, it depends on what you're willing to let me do. I've already made calls to Recovery Works, and I'm in line for assessment with them because I did like that program. It just, honestly, it was my fault, but it was extenuating circumstances. My daughter got kidnapped by my mother on Christmas, and I found out that I was going to get violated anyway because to try to sleep, I went to the corner store and got a little shot. I didn't know they could do alcohol strip test or whatever. Failed for the drug test. And
well, on all that part, let's wait till you talk to Ms. Kirby about that aspect of it.
Right. Well,
let's go ahead and make a referrals for a CBCF just in case, and we'll also make a referral for sober living. We'll come back in a couple of weeks and figure out
can I
what
ask
to
you a
do.
question?
Sure.
I would like to be transferred back to Tennessee because that's where my daughter is. But I talked to my probation officer and she said that I would have to take care of the violation first. Like pretty much what happened last time, I have to go to a program and then get my stuff transferred.
All right.
That's what she told me.
Talk to Ms. Kirby. We'll talk about all those things at the final. I do find that there's probable cause to believe you have violated the terms of your supervision. I'm going to hold you in jail until the final. See you in a couple of weeks.
All right. Thank you so much.
The State of Ohio versus Kyle Clemens. This is case number 24 CR 41519. You can step up to the podium, Mr. Clemens. Present before the court is Mr. Clemens. We have Mr. View from the prosecutor's office and Officer Sukovecki from probation. We're here today, Mr. Clemens, because I've received a report that alleges you have violated the terms of your supervision, that you tested positive for cocaine on July the 28th, that you refused a drug test at the jail on August the 15th, and you are not regularly attending your treatment. You also have the right to be represented by a lawyer in the case, and if you can't afford one, I will appoint one for you. The recommendation of Officer Martinez is that I continue you on intervention in lieu of conviction, set this for a final hearing so that we can get you into some sort of residential treatment, someplace like Christopher House, someplace like that. Do you want to be represented by a lawyer?
I don't. Bear with me. I haven't had my medicine in 6 days, so I can't really hear you.
Okay.
Everything's echoing.
Okay.
So I do apologize.
All right.
I'm trying to make out what you said.
All right. So you have the right to be represented by a lawyer.
Okay.
If you can't afford one, I'll appoint a lawyer for you.
Okay.
Officer Martinez's recommendation is that I continue you on intervention in lieu of conviction. But we don't have a placement for you yet. Her recommendation is Christopher House, but I'm going to set this for a final hearing. That's going to be in about a week to 10 days. And hopefully we will know what the results of the referral to the Christopher House is.
Okay.
So if you want me to appoint a lawyer to represent you, I can. If you want to hire your own lawyer, you can do that.
How would I go about doing that being in here?
It's tough to hire a lawyer from jail, but
I try, to be honest with you, like I've learned my lesson. I know I tested positive. Emotion took over, completely with my decisions, and I trust Miss Martinez. So, I'm not going to need an attorney.
All right. So I'm going to have Ms. Kuroko give you a waiver of counsel to execute. That tells me in writing that you don't want to be represented by a lawyer.
Where at? I'm sorry.
I'm going to accept your waiver of counsel. Do you admit or do you deny that you violated probation?
I admit, Your Honor.
All right. Based upon your admission, I find you have violated the terms of ILC. I'm going to set this for a final hearing in about a week to 10 days when we get the results of the referrals back, and we're going to figure out what to do about this. Okay?
And what can I do about my medicine, Your Honor? Like, I'm seizing out.
Okay.
I'm on mental health medication. I've been here for 6 days and I haven't had my medication.
Okay. I can have my bailiff, Ms. Carilco, email the jail.
Okay.
That's about the best I can do.
Okay.
The sheriff and I have a long-standing arrangement. He does not tell me how to run my courtroom, and I do not tell him how to run his jail. But if it's a mix-up or something like that, maybe we can get that taken care of.
Okay. Thank you, Your Honor.
Okay. Next is the case Harry Johnson. This is case number 24, CR 41798. Present before the court is Mr. Johnson, right?
Yes, sir.
We have Mr. View from the prosecutor's office and Officer Sukovecki from probation. We are here today because I have received a report that alleges that you have violated the terms of your supervision and that you got into a fight in the jail on August the 15th. You have the right to be represented by a lawyer. If you can't afford one, I'll appoint a lawyer for you. Do you want to be represented by a lawyer?
No, man. I don't even see how I would be violated, and all I was doing was protecting myself. He swung on me first.
Okay. Do you want to be represented by a lawyer or not?
Yes.
All right. I think I previously appointed Mr. Swift to represent you. Any reason I shouldn't appoint him again?
No.
All right. Ms. Carilco has an affidavit that tells me in writing that you don't have the funds to hire a lawyer and want one appointed. All right, I do find that you are indigent for the purposes of hiring a lawyer in the case. I'm going to appoint Mr. Swift to represent you. You have his contact information there. We're also going to send him an email today that lets him know that he has been appointed. We're going to set it for a final violation hearing here in a couple of weeks. Okay?
I have one question.
Sure.
Will you be taking the litter getter from me?
That's not up to me. The litter people have kicked you out of their program.
Oh, you already know that they kicked me out?
Yes. I don't run that program. All I do is make people eligible for it, and then the litter getter dudes decide whether or not they want you in their program. Apparently they don't. All right, that's all.
Have a great day, Your Honor.
You too.
All right, Mr. Aguirre, if you would direct someone in your office to correct his name on the docket.
I'll put it in the file, Your Honor.
Señor Aguirre, si por favor pudiera dirigir a alguien de su oficina que pudiera corregir el nombre en el expediente. Sí, lo estaría poniendo en el archivo, su señoría.
Mr. Daniel Miraz, you are charged in count 1 with operating a motor vehicle without a valid license, a Class B misdemeanor.
Señor Daniel Maraz, usted tiene una infracción de la infracción número 1 por operar un vehículo motorizado sin una licencia válida, que vendría a ser un delito menor de clase B.
The penalty for this charge, if you were to be convicted, includes a fine up to $1,000 and a jail sentence up to 6 months, although probation is usually given.
La penalidad por esta infracción, en el caso de que usted sea sentenciado, incluye una multa que puede ir hasta los $1,000 y una asistencia en la cárcel de como máximo hasta 6 meses, aunque usualmente lo que se le brinda es la libertad condicional.
Do you wish to have an attorney represent you on this, sir? You can apply for a court appointed if you cannot afford an attorney, or you can waive your right to an attorney and represent yourself.
Bien, señor, ¿usted desea que un abogado lo represente en este caso? Usted puede hacer la solicitud para un abogado que sea nombrado por el tribunal, en el caso de que no pueda pagar por un abogado privado, o usted puede exonerar su derecho a un abogado y representarse a sí mismo.
Pues voy a pagar la multa.
¿Cuál va a ser la multa?
I'm going to pay the fine.
Does that mean you're going to proceed on your own behalf without a legal attorney today?
Eso significa, señor, que usted estaría procediendo por sí mismo sin un abogado el día de hoy.
Sí.
Yes.
Before we proceed, do you understand, though, that you can hire an attorney, and if you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed?
Antes de proceder, señor, usted comprende de que usted puede contratar a un abogado y si no puede pagar por uno, usted puede hacer la solicitud y ver si califica para uno que sea nombrado por el tribunal.
No, así está bien.
No, I'm fine.
Well, I just need to make sure you understand you have the right to do that if you want. You don't have to, but do you understand you have the right?
Bien, señor, pero tengo que asegurarme de que usted comprende de que tiene el derecho a ello, que si usted quiere, no tiene que hacerlo, pero usted comprende que tiene ese derecho.
Sí.
Yes.
And knowing that you can have an attorney, you wish to give up your right to an attorney and proceed without one?
Y bueno, sabiendo de que usted puede tener un abogado, ¿usted desea renunciar a ese derecho de tener un abogado y proceder sin uno?
Sí.
Yes.
Is anyone making you give up your right to an attorney for
Violation hearing. Mr. Washington, does your client wish to have a hearing on this allegation?
Your Honor, in talking to her, the violations themselves are accurate. I believe that there's an absconding that she didn't report. She acknowledges that she did not report as ordered by the court. And I know she didn't finish the treatment program. I think that we will address that more in mitigation than we are, but the fact of the matter is she did not complete the program as ordered by the court. So we'll admit those violations.
All right, Ms. Dunn, you understand that you are entitled to have a hearing?
You got to speak out because it's recorded.
Yes, sir.
Okay, you wish to waive that hearing and admit to the allegation?
Yes.
Okay. All right, the court's going to find that you have violated the terms of your ILC. Ms. Dunn, I'm going to give your attorney a chance to mitigate this. I'm not really sure where he wants to go with this, so I'll let him go first.
Okay, Judge, thank you. And Judge, I had a chance to talk with my client. She's extremely nervous. She's scared, quite frankly, and she's having a difficult time expressing herself clearly. But my understanding, based on my conversations with her, is that I know with regard to the treatment program she was supposed to complete, she thought that there was a mental health aspect of the program that would be helpful to her, and apparently it didn't. And she got overwhelmed because she has 3 children, and she felt like she wasn't there for her kids, so she did not complete that program. We acknowledge that. She has an ongoing children's services case for her 3 children that she has a hearing scheduled next month that she's on the verge of getting her children returned to her, and she wants to do that as well. With regard to my understanding is she hasn't reported in over 300 days. She indicated she had made some phone calls, that she had been in contact through telephonically. However, she did not report as required. So I just get the impression I've got a really young, somewhat immature person who's going through a lot of life's experiences and challenges and has to learn how to prioritize. Her grandmother's here. Has indicated to me that she does need some assistance to sort of, I guess, navigate life. I know the court sees it all the time, as do I, where these young people take on a lot of responsibility with regard to parenthood and the other things, and they falter on some things that they should have prioritized. And I think that that's the situation we have here. I could just sit and talking to her. I could tell that she's scared, that she's terrified, and that she's got some things she's got to overcome in Indiana. My understanding, the case in Kentucky is one where she was in a car, that she's not the primary person involved in that she's a passenger. And based on my conversations with her attorney down in Kentucky is fairly confident that she's not going to be convicted of any charges in that situation. That being said, we're here for a F5 that she pled to 4 years ago, maybe?
November 23rd of 2021, I believe.
Yeah, almost 4 years ago, Judge. Nonviolent offense. My understanding, talking to her, she was involved with this with one of her children's fathers, who was very controlling of her conduct and her behavior, and he has that relationship has been terminated, and this is maybe the last lingering link that she has. So it's one of these, I don't want to call it a trigger, when she talks about this with this guy who was apparently quite abusive to her. And again, I'm not going to make excuses for her not completing what's necessary through probation, but I think that all of these are factors, her youth, the amount of things she has happening all at once. This is a nonviolent offense, Judge. She's got 90-something days of credit, my understanding at this point. If the court were to terminate her, I was going to say dishonorable discharge, unsuccessfully. I'm sorry, Judge. I think that that's appropriate. At this point, she has served 90 days on an F5. So that's the court take all that in consideration.
All right, what I'm going to do right now is, based upon this violation and the history of the supervision or non-supervision, the court's going to terminate you from intervention lieu conviction. And based upon your previous plea of November 23rd of 2021, I'm now going to find you guilty. As I told you on that day, if you didn't comply, this is what would happen. Now I'm going to sentence you on this felony charge. Is there anything you'd like to say to me? I've heard from Mr. Washington. I don't need to hear from the state, but you have an opportunity to speak now, if you'd like.
Yes, I would like to speak, Your Honor. Everything that Mr. Washington said was true, and it honestly is a trigger. I would just ask if you would allow me to accept the conviction on my record. I know I have fees to pay. I have a job. This is the longest I've had a job since I've been an adult. And, so I can afford to pay, on a payment plan, my fees. If you would just allow me to do time served and accept the conviction. and where I could get my life situated because Judge Steve, I haven't been able to live yet. Since I was 18, I've been back and forth here in this court, and like I told you before, when you had me sit down here in this jail when I was 19, that changed my life. I have not went back to commit crimes. I know it's probably looks bad, but I have not went back to doing bad things or anything like that. I have since left Austin alone completely. I have a protection order against him, and it's got all of my children on there. I do court order therapy through the Department of Child Services for my children to continue addressing my PTSD, my anxiety, and my schizophrenia. And Your Honor, yes, I do accept. I do accept the responsibility for what I have done. But I assure you, I'm not that same girl that you met 5 years ago.
Thank you, Judge.
Thank you. Ms. Dunn, I'll just make a few comments and then I will sentence you. I know Grandma back here is going to agree with what I'm about to say. But even the pending serious charge down in Kentucky, who you choose to hang around with causes you problems. I mean, this guy that was involved in this theft offense, one of the fathers of one of your children. I don't need to hear anything else. Whatever happened in Kentucky, you were apparently with someone else who was into something that probably they shouldn't have been doing. But you're putting yourself in situations by hanging around with the wrong crowd, the wrong people they're dragging you down. Now you have other people in your life, your children, that you are now responsible for. So you need to prioritize, number one, your mental health, your children's well-being, and then everything else that comes around that, job, even your job or whatever else comes up. Those are all secondary to those two things, your own mental health, because you can't help your kids if you're all over the place, right? So take care of yourself, get your children back, take care of your children, and then the rest of and then make better choices. Because in life, every day we're just confronted with all kinds of choices. You make good choices, there's good consequences. But when you make bad choices, there are bad consequences, period. Okay? All right. With that, the court has considered the statements made here today, the purposes and the principles of sentencing, the relevance, seriousness, and recidivism factors. The other thing I want to comment on, and I told Mr. Washington this, I know you've been in contact with my office a number of times trying to set up this turning yourself in. And again, I don't just, when someone calls and says, would you please recall the warrant? I'm going to turn myself in. It doesn't work that way because people call all the time and try to get their warrant recalled and never show up. You did stay in contact with my office trying to set this up, and I know that the magistrate took you into custody last week when I wasn't here, which I would have done the same thing. So I'm certainly not criticizing Magistrate Mall, because I was going to do that anyway, because you kept on kicking down the road. I think you wanted to do the right thing, you knew the right thing to do, and you just couldn't pull the trigger on it. So, this was never going to go away until you faced up to it. Okay? All right. Having said that, I'm of course going to order you to serve 91 days in the Warren County Jail. I'm going to give you credit for the 91 days you've served, so you will be released today. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. Now, you are also, I got to tell you this, even though it's not going to apply, you're subject to a discretionary period of post-release control, which means that if I sent you to prison, when you are released, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time you are sentenced to. You also have a right to appeal this court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, I know this doesn't really make any difference, but
He's got to do it for the record.
you're not going to appeal this, I'm guessing. If you want to appeal, you must file your notice within 30 days. If you need anything for your appeal that you can't afford to do, that could all be provided to you at no cost. Ms. Nicholson, is there anything else?
No, Your Honor.
Mr. Washington.
No, Judge, thank you.
Ms. Dunn, best of luck to you. All right.
Your Honor, do you want that to be a neutral or unsuccessful?
She's not being placed on community control. I'm just flat out sentencing her to 91 days with credit, no community control involved. She was already, the punishment basically for her is the 91 days she served, and now she's got a felony conviction. So she can deal with that, and Mr. Washington can tell her how to seal that in 3 years. So we can deal with that down the road. All right, thank you all.
Thank you, Judge. I told you just gotta talk to me. I know, it's emotional time. The judge did. The judge did what was fair. You have served 91 days in jail. So, well,
Well, so I'm doing
but
it.
you have a felony now, 3 years from today. 3 years.
Just north of Augusta.
Asumo que esa es la pista que se encuentra cerca a la iglesia, que se encuentra sobre la OH Street, al norte de Augusta.
Your Honor, the ticket in this matter does appear to refer to a location on 1100 West 21st Street North. The state understands that is within Butler County boundaries, specifically within Andover city limits, in close proximity to a medical facility commonly known as Kansas Medical Center.
Su señoría, esta infracción de este caso aparentemente se refiere a la ubicación 1100 West de la 21 Street Norte y el Estado entiende que se encuentra dentro de los límites del condado de Butler, específicamente dentro de la ciudad de Andover y con una proximidad cercana a las instalaciones médicas comúnmente conocidas como Kansas Medical Center.
Would you agree, Mr. Daniel, that that's the area you were in?
Señor Daniel, ¿usted estaría de acuerdo que ese es el área en la cual usted se encontraba?
Sí.
Yes.
All right, I will accept your plea, finding that I have jurisdiction and finding you having knowingly and voluntarily entered this plea. So I will find you guilty.
Bien, señor, estaría aceptando su declaración de responsabilidad, confirmando de que es mi jurisdicción y también confirmando de que usted ha ingresado esta declaración de responsabilidad de forma consciente y voluntaria, así que lo encuentro responsable.
A couple of follow-up questions, though. Is anyone making you enter this plea today?
Bien, tengo un par de preguntas de seguimiento para usted, señor. ¿Hay alguien que esté forzándolo a que declare su responsabilidad del día de hoy?
No.
No.
And do you understand that if I continue to accept this plea, you will not have a trial? You will have given up your right to trial. You will be found guilty and sentenced today. Do you understand that?
Bien, señor, ¿usted comprende si continúo con la aceptación de su responsabilidad? Usted no va a tener un juicio, usted estaría renunciando a su derecho de tener un juicio y a usted se le estaría encontrando responsable y sentenciado el día de hoy. ¿Usted comprende ello?
Sí.
Yes.
And that is how you want me to proceed still.
¿Y esa es la forma en la cual usted aún así quiere que proceda?
Sí.
Yes.
All right, then again, as I said, I find you guilty. And are there any recommendations from the state before I determine sentence, Mr. McGear?
Bueno, como dije anteriormente, lo encuentro responsable y ahí habría alguna recomendación por parte del Estado antes de que yo haga la determinación de la sentencia, señor McGear.
Yes, Your Honor. The state understands that This is defendant who appears pursuant to the notice to appear date on the ticket, and it would appear that the defendant has entered a guilty plea to count one, which does appear to be a Class B misdemeanor based off the ticket. The state understands the court has previously referred to the particular facts of this case as indicated on the ticket, which the state does have particular concerns about given the nature of this matter. To that end, the state is recommending a $300 fine, that the court impose court costs, that the court impose the maximum underlying sentence allowed by law for a Class B misdemeanor of 6 months. The state is not opposed to non-reporting probation in this matter. However, the state is recommending a non-reporting probationary period of 12 months.
Sí, su señoría. Perdón. Sí, su señoría, el Estado entiende que, bueno, el acusado, bueno, aparentemente tiene la acusación de esta fecha en la infracción, y bueno, y aparentemente el acusado ha entrado o ha ingresado su declaración de responsabilidad a el delito número 1, que aparece como un delito menor de clase B, basado en la información de la infracción. El Estado comprende de que el tribunal anteriormente se había referido a estos hechos en particular de este caso, tal como se indicó en la infracción. Lo que el Estado tiene preocupaciones particularmente debido a la naturaleza de este caso para esa finalidad. El Estado estaría recomendando una multa de $300, que el tribunal imponga los costes de tribunal, que vendrían a ser los máximos subyacentes a la sentencia permitida por la ley por un delito menor de clase B de 6 meses. El Estado no se opone a la libertad condicional sin reporte en este caso. Sin embargo, el Estado está recomendando un periodo de libertad condicional sin reporte de 12 meses.
Right, Mr. Daniel Meraz, the state has just given me their recommendations before I set your sentence. You're welcome to make any recommendations you want. You don't have to say anything, but I would consider what you have to say, if anything.
Bien, señor Daniel Meraz, el Estado acaba de darme sus recomendaciones antes de que yo establezca su sentencia. Usted está invitado a hacer alguna recomendación que usted desee. Usted no está obligado a hacerlo, pero considere cualquier cosa que usted tenga que decir en el caso de que haya algo.
Todo está bien.
Everything is okay.
All right, then, sir, your sentence will be a fine of $300 plus court costs of $108 for a total due of $408.
Okay.
Bien, señor, su sentencia sería de una multa de $300 más costes de tribunal de $108 por un total de $408.
Are you able to pay that today, or would you need some time? I can give you some time to pay if you want.
¿Usted está en la capacidad de poder pagar el día de hoy o necesitaría tiempo? Le puedo dar algo de tiempo para poder pagarlo si usted así lo desea.
I'll pay today.
You can pay the $408 today.
¿Usted puede pagar los $408 el día de hoy?
Yes.
Yes.
Sí.
Very well. Your sentence will also include a 6-month jail sentence, which will be suspended. You will not have to serve that as long as you successfully complete a 12-month or 1-year non-reporting probation.
Bien, señor, su sentencia también incluía una sentencia de 6 meses de cárcel, la cual sería suspendida. Usted no va a tener que cumplir con ese tiempo de cárcel siempre y cuando usted complete de forma exitosa un periodo de 12 meses o un año de libertad condicional sin reportarse.
You will not have to see a probation officer, but for the next 12 months, you will be on probation.
Usted no va a tener que visitar a un funcionario de libertad condicional, pero por los siguientes 12 meses usted va a estar en un régimen de libertad condicional.
If you violate your probation in the next year, it could be revoked and you could have to serve the 6-month jail sentence.
Si su libertad condicional en ese año podría ser revocada, perdón, su libertad condicional en ese año podría ser revocada y usted tendría que hacer o cumplir con los 6 meses de sentencia en la cárcel.
So if you do not want your probation revoked, you need to make sure you understand the following terms and comply with them for 1 year.
Ahora, si usted no quiere que su libertad condicional sea revocada, usted necesita asegurarse de que comprende los siguientes términos y cumpla con ellos por 1 año.
First condition of probation is to violate no laws for the next year.
La primera condición de la libertad condicional sería no infringir ninguna ley durante el siguiente año.
The second order of condition is to pay the $408 today at the clerk of the district court office before you leave.
La segunda orden de la condición de la libertad condicional es pagar los $408 el día de hoy y el secretario de la oficina del Tribunal del Distrito antes de que usted se retire.
And the third and final condition is that you make arrangements with the officer to get your picture and prints taken today.
Y la tercera y última condición es de que usted haga los arreglos necesarios con el oficial para que pueda obtener una fotografía y también sus huellas dactilares el día de hoy.
Deputy,
Okay.
he will not have to post a bond because he does not have to come back to court unless he violates his probation.
Secretario, él no tiene que pagar la fianza debido a que él no tiene que regresar al tribunal a menos de que él infrinja su libertad condicional.
Of course, if he's already been processed, he won't have to repeat it.
Yeah, we've set him up to go out and get it done.
Sí, estamos programándola para poder sacarlo y terminarlo.
Do you need him to visit with you and the interpreter in a breakout room, Deputy?
No, we've already given him that date for his fingerprints.
Okay. All right, is there anything else, Mr. Regier, we need to take up in this hearing?
Señor Reguera, ¿habría algo más que nosotros necesitáramos tomar en cuenta en esta audiencia?
Not from the state's perspective, Your Honor.
No desde la perspectiva del Estado, su señoría.
All right, we'll be in recess then unless Mr. Daniel Meraz has anything further.
Bien, en todo caso pasaríamos al receso, a menos de que el señor Daniel Meraz tenga algo más que mencionar.
No, todo está bien. Gracias.
No, everything is okay. Thank you.
Thank you, and I want to note that the officer wrote on your ticket that you were very polite and respectful to him. Thank you for that, sir.
Muchas gracias y también quiero anotar de que el oficial, el funcionario escribió en su infracción de que usted fue bastante amable y respetuoso hacia él. Así que muchas gracias por ello, señor.
Gracias a ustedes también.
Thanks to you guys also.
All right, you may go, sir, but don't forget to pay.
Bien, señoría, se puede retirar, pero no se olvide de pagar. Okay.
Bye-bye.
Hasta luego.
Mr. Vigo, would you see if anyone else needs a Spanish interpreter before I release you?
¿Habría alguien más presente en la sala que necesite los servicios del intérprete de español?
Well, seeing and hearing no response, then I trust we've covered the docket of Spanish speakers. So thank you, Mr. Vigo, for your time and sharing your skills with us. And until next time, you're free to go.
Thank you, Your Honor. Have a nice day.
Thank you. You too.
Judge,
Yes.
just to let you know, I've got 13 more people here at the Sally Port.
All right. I'll try to balance them off with those that are on the screen. Who do you want to do first? Do you have a Sean Newman? I have a note that Sean Newman is anxious. He has another obligation or something.
Yeah, there's two CSOs on here for him.
Oh, a CSO is on here for Sean Newman. Where is Sean Newman? Let's call him up next. Thank you, Missy.
Sean Newman. Hey, I got him here at the Sally Port.
Let's bring him up.
All right, he's here.
We are on the record in 2022 TR 59, State of Kansas versus Sean Warren Lamont Newman. Jared Regier appears for the state. CSO, is that who you're here for, Marcy Taronis?
Yes, it is. And I also have Julie McClendon from Cedric County here as well.
Julie McClendon from Cedric County Probation. Last I knew, Darren Patterson was his attorney. Mr. Newman, are you still going to have Mr. Patterson as your court-appointed attorney?
Yeah. Yes.
All right. And have you talked to him about being here today?
No, not today. I didn't get a chance to speak to him today.
Are you going to hire him or are you applying for court-appointed?
I usually go for court appointed.
Right. Have you filled out an application for court-appointed attorney?
No, not yet.
Have you changed any financial circumstances since Mr. Patterson was your attorney?
No.
Well, you do have the right to an attorney since you're looking at having your probation revoked and to serve your jail sentence. Are you going to ask for an attorney then, or are you proceeding on your own behalf today?
For an attorney.
All right. Well, CSOs, we may have to continue this to get his attorney here, and it'll probably be on a Monday or a Wednesday afternoon. Is there one day that's better for the probation officers than the other, a Monday morning or a Wednesday afternoon?
As long as I'm sorry, I'm sorry, Marcy.
No, go ahead, Julie.
As long as I have notice, either one works for me, Your Honor.
All right, and CSO Julie, what's your last name?
McClendon, MC.
Market states 345. Tell me what she recognizes 345 to be.
What I'm looking at, 345 is going to be the Miranda rights that was read to Mr. Avery, Quandor's Avery, and this is going to be also the form that he signed.
And is the form appear to be altered or changed in any way?
No.
Is it in the version form that you handed to him on February 2nd of 2021?
Yes.
Thank you. And at this time, the superintendent to the records 345.
There's no objection.
Is it the thank you.
Detective, let me ask you first. You've been given your Miranda form, correct?
Yes.
And that's the form that you utilize for people to sign so that they understand the rights that they're giving up. Am I also correct?
That's correct.
All right. Now, when you spoke to Mr. Quandor's Avery, it wasn't as soon as the shooting happened, correct? It was several months later. Is that correct?
That is correct.
Okay. And when you spoke to him, he was incarcerated. That also correct?
Am I allowed?
Yeah. When you spoke to him, he was incarcerated.
That's correct.
That's fine. Now, at the time that you spoke with him, I understand at that time you did not know whether he was represented, correct?
That's correct.
Right. But now you've come to learn that at the point where you were speaking with him, he was actually represented by counsel. He had a lawyer.
He had a form that was submitted, yes.
So he had representation.
Yes.
Okay. And I think you testified previously. Well, let me just ask the question. You try to make it a point to find out whether someone who you're speaking to has representation. Am I right?
Yes.
You try to do that beforehand.
Yes.
In this particular case, you didn't know, correct?
Yes.
Okay. And part of the form actually says that if you are represented by counsel, that counsel has the right to be with you while you're asking questions. Am I correct?
Yes.
Okay. But he didn't get that opportunity. Is that correct?
He waived them.
Okay. He didn't get that opportunity because you didn't know that he had an attorney.
He waived his rights.
Did he know? Did you know that he had an attorney?
He didn't tell me he had an attorney either.
Right. My question is, did you know that if he had an attorney? Did you try to find out whether he had an attorney?
Usually when somebody's incarcerated and we're about to do an interview, if they know they have an attorney, they'll let us know they have an attorney.
You said it's your practice,
right?
Your practice to find out whether they had an attorney, not your practice to find out from him whether you had an attorney.
That's correct. What I'm saying is usually a person who has an attorney will come out and tell you right then they have an attorney.
But you didn't try to find out whether he had an attorney.
I didn't find out, no.
Okay. But when he spoke with you, one of the first things that you've been speaking about on direct examination is that he explained to you how he actually got to Biscayne, right?
That's correct.
Okay. And one of the things that he explained to you is that there was a conversation that was overheard, correct?
Correct.
Now, in that conversation from the recording, when asked by you what was said, he said, "I don't remember." Do you remember that?
Correct.
Part of it said, "I don't remember exactly what she said."
Correct.
Okay. But he understood that his brother was leaving the home. Am I correct?
And he understood the incident took place by them being choked out.
Right. He understood his brother was leaving the home.
He understood that an incident took place where the girls said that they were choked out.
Right. Now, he didn't encourage his brother to leave the home.
No.
In fact, he discouraged his brother from leaving the home. He didn't want him to leave.
Correct.
Right. That's corroborated by Claiborne himself, because you spoke to him, correct?
That's correct.
That's corroborated by Tenoris, because you spoke with him.
Correct.
That's corroborated by the Andrews sisters, because they're the ones who are the subject of all of this. Am I right?
That's correct.
No one from that group encouraged Claiborne to go. Am I correct?
No.
He did it on his own.
That's correct.
But he wanted to be with his brother because he just wanted to be with his brother. He wanted to look out for his brother.
That's correct.
Right. Now, on the way over there is conversation in the vehicle.
That's correct.
And to your knowledge, from Claiborne, from his statement, from what he told you, he didn't tell his brother, "I'm going over there to whip his tail," right?
Correct.
He didn't ask his brother to be involved in any of that. Am I correct?
That's correct.
That's corroborated by the Andrews sisters, correct?
Correct.
By Mr. Claiborne himself.
Correct.
That's corroborated by Mr. Tenoris Avery, correct?
Yes.
So he's driving, but he's not the one that's actually driving the vehicle.
Correct.
Do you remember in the statement that was just played, he said, "Park over here," right? He says, he says to him, "Park over here in case we got to run."
Correct.
Okay. Because he didn't know what those people were on.
That's right.
Now, from speaking with Claiborne, the Andrews sisters, Tenoris Avery, he never had his gun out in the car. Am I right?
No more mention that.
Okay. And no one mentioned that they knew whether he had a gun or not. Am I correct?
During the interviews? Yeah. When I interviewed, I believe one of the Andrews sisters knew that they had guns on them.
Okay. None of them said that they saw a gun on my client, though.
They just knew they had guns on them.
Who said that?
The Andrews sisters.
They both said, is that what you're saying?
Yes, it's saying that they knew that they had guns.
Okay. All right. So you're saying an Andrews sister said that they knew that Mr. Avery had a weapon on him.
I didn't say Mr. Avery. I said they knew that they had guns.
Okay. So you're not saying Mr. Avery, but just they in general.
Correct.
Got you. Now, when they arrive at the scene and they park, one of the conversations I think you said that in your conversation with Mr. Avery is that he saw part of the altercation inside.
That's correct.
Okay. He's not the individual that knocked on the door, correct?
You're correct.
He's not the individual that allegedly kicked in the door, correct?
Correct.
He's not an individual that went inside, correct?
Correct.
He's not an individual who helped in any way in the fight at all.
That's correct.
Even though he was there for his brother. He did not get involved in any of that altercation, right?
That's correct.
And him not being involved in that altercation, he then tells you that he sees a gentleman walking around with an AR-15 rifle. Correct. Now that's consistent with the evidence. Am I correct?
Yes.
So the evidence showed that there was an individual who got out of a vehicle with an AR-15 rifle.
Correct.
Right. There's evidence also that is consistent with him shooting that AR-15. Correct.
That's correct.
There's also evidence that's consistent with him at least pulling the trigger, causing a jam in the weapon. Were you familiar with that?
Yes.
Okay. But what he indicates to you is that when he was out there, he didn't have his gun brandished, correct?
Correct.
Okay. But Mr. Devinson did have his gun brandished. It was out.
It was out. Correct.
He said that initially that it was pointed, he said, to his ankles.
Correct.
He told you? Okay. But he also indicated to you that he told him, look, chill out. Right?
Yes.
And at that point, he had his gun. He put his hand on his gun.
Yes.
And he started to back away.
Yes.
At that point, he indicates to you, and I think that's what we just heard, was that he saw his elbows come up and his shoulders shrug.
Correct.
And then as he raised up, that's when Quandaris Avery raised up. Correct?
Correct.
And when Quandaris Avery raised up, that's when he fully raised up. The he meaning Mr. Devinson fully raised up and shot the weapon. Correct?
He didn't fully raise.
Who did fully raise?
That's not completely what he said. That's not.
I didn't say fully raised. I just said raised. I apologize. If I say fully raised, that's not what I meant.
Okay.
What I meant was he raised it even more.
Correct.
And then he shot.
Correct.
Now you're familiar with weapons, correct?
Yes.
You could have from here. You could have been shot.
Correct.
From here you could have been shot.
Correct.
From here you could have been shot.
Correct.
It doesn't take someone to fully raise for someone to be shot with an AR-15 rifle. Correct.
Correct.
Now, once and I think this has already come out, but as he was leaving, didn't he tell you that, in fact, he saw someone removing the weapon?
Yes.
Okay. And that turns out to be true. That is a true fact, correct?
That is.
And so the fact that he had a weapon, that's a true fact.
Correct.
The fact that he shot is true.
Correct.
The fact that he was called over there by one of the people in the home is true.
Yes.
Now, did Mr. Devinson ever go into the home where the altercation was, to your knowledge, based on the statements in your investigation?
I didn't have anything happen.
Okay, so he didn't go into the actual house to protect his niece from anything. Am I right? Am I right?
No, he didn't go in.
Okay. But yet that was his stated purpose. Right? That's why they said he was there.
Okay. Yes.
Now, do you know who G is?
I don't. Oh, I'm sorry. Is that George?
I don't know. Do you know who G is?
I'm gonna say no.
Okay. Are you familiar with how Mr. Devinson received the weapon?
Which Devinson?
The deceased Mr. Devinson, Mr. Damon Devinson.
Okay. No.
Are you familiar? So you don't know that?
No.
Okay. So you don't know whether a G provided the weapon to him?
I don't know.
All right. No further questions.
Morning again.
Good morning again.
I'll be brief. What I think I heard in that interview was that at some point, Mr. Devinson, I think the phrase was he raised the gun the first time. Did you hear when he said Mr. Devinson raised the gun the first time? When he raised the gun the first time.
Oh, yes.
Which indicates that Mr. Devinson raised the gun more than that one time, correct?
Correct.
And isn't it also correct that when Mr. Devinson was on the ground, he was still alive, correct?
I wasn't there. I don't know if he was. Actually, he was still alive because he was deceased at the hospital.
Right. In fact, he died some hours later in surgery, correct? So as he lay there on the ground after having presumably been shot, he was still alive, correct?
Correct.
And isn't it correct that that shot that was fired in the back area that went out the armpit, it never actually entered the body cavity, correct?
I'll have to go back and look at autopsy.
Well, would it refresh your recollection to take a look at that report?
Yes.
May I approach the witness, Your Honor?
Yes.
You take a look at that, read that
Your
line.
Honor, before he ends, will you briefly approach?
Yes. And if you want to go.
Oh my God. So you want to read from start to end?
Yeah, just read it to yourself, and when you're done, just look up.
What?
Isn't it correct that that bullet never entered the body cavity?
Correct.
And in that statement where you spoke with, or in that recording where you spoke with Mr. Avery, Mr. Quandaris Avery, what the words that he said and that you testified to was that Mr. Quandaris Avery said that Mr. Tenoris Avery could have just knocked him upside the head, correct?
Correct.
Isn't it fair to say that at that point where Mr. Quandaris Avery was suggesting that Mr. Tenoris Avery could have just knocked him upside the head, that Mr. DeVezin was still perceived as a threat?
Objection, Your Honor, cause of speculation.
Your Honor, this would come directly from that statement, and it's a logical inference that a detective is capable of making based on that statement. He could have knocked him upside the head, Your Honor.
That's argument. We can make it closing.
Just a question. But it is correct. He said you could have just knocked him upside the head, correct?
That's correct.
And when that person said, "You just killed my uncle," do you know if that was the Courtney person we spoke of earlier?
I'm not aware of which female that was, but it was just yelled.
Now, did you ever yourself go into that home, that apartment?
I've been there.
And it's a very small apartment, isn't it?
It is.
And from the vantage point of that parking lot, it is correct, or it is accurate that one can actually see inside that apartment, correct?
From the doorway?
Yes.
Yes.
As well as standing in the parking lot, one can still see inside the apartment, correct?
It's depending on what angle you're standing at, yes.
One second. Thank you, sir. I have no more questions for you.
Thank you.
Any regret? Detective King, did you personally inspect the rifle that was discovered in the Suburban?
When it was originally found? When it was originally found, no. That would have been Detective Rick Berg.
When did you inspect it?
I initially got to see it back at the crime scene.
And after you saw it, what happened to the rifle? Did you turn it over to Jay Jarvis or someone else?
I submitted it into our evidence and property, and from there, it would have got submitted for further testing.
Did you manipulate the rifle in any way before handing it to Jay Jarvis?
Oh, no.
Okay, thank you.
Oh, so what's that question? Sorry.
Did he manipulate the rifle in any way before handing it to Jay Jarvis?
No recross, Judge.
Okay, happy then.
No questions.
Can you be excused? Yes.
Thank you.
Any other rebuttal witnesses? No, Your Honor.
State Russ again?
Again.
Okay. Is anyone else calling another witness?
Your Honor, Mr. Shanoris Avery would like to call Mr. Claiborne Avery.
Okay, and is he already upstairs?
Yes, Your Honor.
Okay, would you guys step out so we can bring him out?
All right, Judge Jury.
Okay, we have a little bit of housekeeping to take care of. First, we had three, I think, pretty long conversations at the bench, and I want to make sure the defendants know what that was about. The first argument at the bench, as I recall, was about clips being played and whether a portion of the clips involving the defendant saying something about the moon. Is that right? Do you want to articulate that better, what you wanted out?
Yes, Your Honor, there was a statement that was made in response to one of the detective's questions where he states essentially why he went over there concerning his brother. And then it goes into statements about him shouldn't have been outside because there was a full moon, and which correlates with their religion, and which was spoken about at length for Mr. Claiborne. And I didn't think it was relevant. I didn't think I had really standing concerning Mr. Claiborne, because it might be relevant to him, but it certainly was not relevant to my client. But any mention of that would have been sort of non-responsive to the reason why they were asking this detective the particular question of why did he go over there, which is that he was going over there to see about his brother, which the detective actually said on direct examination.
Okay, and ultimately the state compromised by playing just a portion of that statement, essentially that he should have listened to what he preached and not gone over. Is that correct? Okay. And then next, there was an issue about the Miranda waiver form that the state wanted to present as evidence, and I initially ruled that out because the evidence is being used for impeachment. I always like to admit when I'm wrong, and I was wrong. So I'd cite everyone to the Court of Appeals case, actually, of Green versus State, because it does a very nice summary of all the Supreme Court law and the Georgia law on this. It's at 159 Georgia Appeals 295. So a couple things. First of all, in this instance, I had originally found that the statement was voluntarily entered and freely made without any coercion or promises of benefit. The law is pretty clear that if the statement is involuntary or coerced, then it may not be available for impeachment. But if it's a procedural issue, such as the right to have counsel present, it's still available for impeachment. And that's what that case stands for, essentially. It did provide warning that I've got to continue looking at in terms of providing some kind of a charge, essentially that impeaching evidence is not used as substantive evidence of guilt, but instead as impeachment. I'd like all of you to consider what that charge should be, and then we'll give that as part of the closing charge, unless you want it sooner than that.
Your Honor, that works in conjunction with the impeachment.
Right, we can just add that to the impeachment.
Have no
Yeah.
question.
Okay, so if there's anything special you want on that, let me know. I'm very open to it. There was cautionary instruction of given instruction on this. Okay. Okay, and then finally, there was an argument at the bench about Mr. Ragus crossing the witness about whether a graze wound was tantamount to hitting a victim upside the head. Again, there was compromise, and he didn't continue to make that argument. He just was able to establish that it was a graze wound, that one of the wounds was a graze wound. Is that everyone else's recollection?
Yes, Your Honor.
Okay, any objections to any of that at this point?
Not from the defense.
No objection, Your Honor.
Okay. And so what's happening with your plea? Are you going to lose your opportunity if we don't send you to do that right now, or can you do that after Mr. Avery testifies?
I'm actually trying to see if somebody else can handle it. I'm getting messages back and forth.
Okay, well, do you want to take a minute and do that and find out
Yes, Your Honor.
what the deal is? Okay, that's fine. And if you need me to contact the judge, I'm happy to ask her to just keep him upstairs for another hour or 45 minutes or however long this is going to take. And then, are you closing? Are you doing closing?
Yes, Your Honor.
Okay.
I'm just the help.
Judge, I accounted for.
Since he was excused, let's just put him under oath again.
Here, raise your right hand for me. Do you swear affirm the testimony you give to the court is the truth, the whole truth, so help you?
Yes.
It's a Mike State, spell your name for the court.
Claiborne Avery, CLAYBORNAVERY.
Good morning, Mr. Avery.
Hey, how you doing?
I'm all right. How are you?
Good.
So I have a few questions for you. I want to get into why you went to JR's house. You were here already. You testified that you heard about some stuff that had happened. Isn't it true you went there for a fight?
Yes.
Okay. Had you been to JR's house before?
Yes.
What were those circumstances that you went to his house?
What's the reason I went to the house?
On the other occasions?
Just to chill with him. Like, chill.
Okay. And JR never told you that you weren't welcome at his house?
No.
Okay. When you go there, can you see inside the apartment from the street?
Yes.
Okay. You also mentioned when you were here before that you handed your gun to your brother Tenoris.
Yes.
In relation to the door of the apartment, where was he when you handed him the gun?
By the door.
Okay. Was he right behind you when you handed him the gun, or was there other people around? Kind of describe that scene for us.
Yeah, it was like Not like the living room not that big, so we were kind of close. It was
So-
me, Vandy, Shalisha, and my brother.
So were the girls right behind you or was your brother right behind you?
Vandy was closer to me than he was.
So you had to reach over them to
Yeah,
give the gun to your brother.
Yes,
Okay. And everybody was at the doorway when that happened?
yes,
Okay. So you said you got into a fight when you got there.
yes.
So tell me how you got into this fight. You got to the door. Was the door open?
No, I knocked on the door.
Okay. You knocked on the door. Then what happened?
The female that was inside the house, she opened up the door.
Okay. Did you see JR when she opened up the door?
Yes,
Okay. So did you have any words with him?
yes,
And did he respond to you?
in a way, yes.
What way did he respond to you?
Like when I asked did he put his hands on my girl, he was like, he stood up on some, like basically telling me, yeah. Well, he told me yes, he did, but like he stood up on like on some body gesture, like yeah, he wanted to fight, but it was just crazy to me that he did something like that because I looked at that as like I look at my brothers, you feel me? Like, I treat him like a brother, so it kind of made me mad when he did that. So yeah, I went over there not on nothing like that. I just went over there like I'm confirmed as a brother. So yeah, I went over there to fight with him.
Okay. So you went over there to fight with him. Did you make that intention known that you went over there to fight with him?
Yes.
How did you do that?
As soon as I got into the apartment, I ain't gonna lie, I had told him like my body gesture, I ain't gonna lie, he knew it. Like I ain't gonna lie, he felt it because I asked him, I'm like, you put your hands on my girl, and when he said yes, he stood up. And when he stood up, that's my pass gun to my brother. I hit him.
So have you ever heard of the term square up?
Yeah.
What does that mean?
It mean like two people getting ready to fight.
So how do you know if somebody's squaring up?
They body language.
Okay. Can you describe the body language?
I mean, like as in, okay, for instance, like somebody push up on me
Mm-hmm.
in a way, and I know that I did something wrong,
Mm-hmm.
and yeah, like I'm going to stand up. I'm gonna get in defensive mode
Okay.
to protect myself.
So I've heard the term square up before. I'm gonna demonstrate what I think it is, and you tell me if you would agree with that.
Yes, ma'am.
If somebody approaches you and they're adjusting their shoulders, what does that mean to you?
They getting ready to protect themselves. They really ready to fight.
Is that a square
They
up?
loosening themselves up. They loosening it. You can say that. You can say that.
Is that kind of what you two were doing when you talked about body language?
Yes.
Did he tell you he didn't want to fight?
No.
Did he tell you to leave?
No.
Okay, give me just 1 minute. No further questions. Thank you.
You're welcome.
Any questions?
Just briefly, Mr. Avery, you stated just now that when JR stood up, acknowledged that he had hit Vandy, you hit him, is that right? Thank you, nothing further.
Did you answer? Couldn't you?
Oh, yes.
Okay, thank you.
Okay, can we excuse him?
Yes, Your Honor.
Okay, thank you. Oh, you can walk in. Oh, unless it's your decision. Okay.
What happened during?
Okay. Okay, is everybody ready to rest again? Anything else? Any more witnesses? Okay, do you want to rest in front of them? Or do you want me just to
We can
rest on the record?
Yes, Your Honor.
Okay. Okay, so what we can do is send them to lunch and then go into closings, right? We don't have anything else before closing. Okay, we need to let Ms. Broderick go take her plea there on holding your client. And you think, is she pretty quick? I don't know.
Yes.
Okay. Okay, that doesn't go on the record, that part. About my colleague. Then my inclination is to give them until 12:30 for lunch. Does that give you guys enough time? And then if we can come back at 12:15 to talk about the charge? Or do you need to do that now before you go? Oh, you're fixing your PowerPoint. Okay. Okay, well, before you go, can we talk?
Yes.
Yeah,
Yes.
okay. So let's go ahead let's get back into the charge now.
When you said, is she quick? I thought you meant my client.
Oh,
He is.
okay, I get it. I hear what you're saying. Okay, okay. Laura, are you listening? Okay, okay. Will you let the jury know that we have housekeeping and we'd like them to come back at 12:30 for closing arguments? Okay, thank you. Thank you for checking first. Okay. Okay, so it looks like we are on page 8.
Lendon.
We have an attorney, William McClendon in Eureka. Is he related?
Married into it, so I'm not aware.
All right. Well, he's a fine young man and a good attorney, so you do your family well if he's not related or if he is, but it's William McClendon out of Eureka. All right, so we'll try to give you enough notice. What do we have available, clerk? What's clerk did I say I'm using again? Is that Jenna?
Destiny, Your Honor.
Destiny, when can we move this maybe to, I'm thinking a Wednesday afternoon that Mr. Patterson might already be committed to?
Well, I'm not sure on that one. I had a Monday of November 10th at 9 a.m. if that would work, but I can also look for a Wednesday afternoon.
I think Wednesday afternoon might fit the court's schedule a little better. He's usually here on the interpreter docket. I don't really want to put it on that, but maybe if we put it at the top of the interpreter docket.
Um,
And Mr. Regier, feel free to make recommendations on this matter. I don't like to set the show causes over too long, so if we have to go with a Monday, that'd be fine too.
I think the earliest that I really have, Your Honor, is going to be October 22nd. That's a Wednesday afternoon at 1:30.
All right. Is that far enough, you think, out, Ms. McClendon, that you might be able to be back by Zoom again?
I show that October 22nd through the 24th, we have our CAXO meeting.
Okay, I'm not sure what that is, but that sounds like a not available to me.
Yeah.
Court appointed something, maybe. Court county.
Yeah, it's the Kansas Association of Court Services Officers.
Okay, that sounds like Ms. Taroni's might be unavailable as well, so. Well, what else do you have then, Destiny?
The week after on the 29th?
October 29th will work for me.
All right, we'll set this over to October 29th at 1:30. Mr. Newman, I'm going to order that you be present at the courthouse again like you are today. That is our district policy for show cause hearings, is that the defendant be in the courthouse. So, and then Mr. Regier, I trust that'll give you time to re-subpoena Ms. McClendon and Ms. Taroni's.
I should imagine so, Your Honor. Stu would also request clarification as to whether the court is continuing the bond in this matter.
Looks like his current bond is a $1,000 security with second chance bail bond posted May 28th, 2025. I will continue that bond, Mr. Newman, with the added condition that you be back here at that date and time in the courthouse, and that if you're going to apply for attorney, you get that done before you leave the courthouse, get it back to the officers once you find out who the court-appointed attorney is, probably Mr. Patterson, you get a hold of him and be prepared for this hearing come the date that I gave you of October 29th at 1:30.
Okay.
Anything else, Mr. Regier?
Not from the state, Your Honor.
Anything further, Mr. Newman?
No, Your Honor.
All right, get that filled out and leave it with the officer. Thank you. And then call back in a couple of days to find out who the attorney is for sure, if you don't know when you leave the courthouse.
Okay. Okay.
CSOs, do either of you want to see him between now and then?
I already have an appointment set for him to report to me this afternoon.
All right, well, common sense would say you probably ought to be on your best behavior between now and the show cause hearing. All right. And Mr. Newman, have you been advised of what the allegations of violations are?
Yes.
Okay. You don't need me to go back over those with you?
No, ma'am.
All right, talk to Mr. Patterson about those before court. You may go then. You are excused, Ms. McClendon. Thank you for making yourself available and for this supervision. You're excused. And
Thank you, Your Honor.
You're welcome. Ms. Taronis, do you have anyone else on the docket today?
I do not, Your Honor.
All right.
Yeah, fill it out and get it back to us. Okay.
And then the deputy will tell us who's next.
Last name Mendoza.
With what letter?
First
of V?
name, huh?
Is that a V, Victor Mendoza, did you say?
No, M. Mendoza.
Okay.
What's your first name? Prisciliano. Bryce Prisciliano Mendoza.
All right, we are on the record in 2022 TR 2328, State of Kansas versus Prisciliano Mendoza. Jared Regier for the state. Defendant appears in person and pro se. I show you've had Darren Patterson before, though. Is that correct?
Could you repeat yourself?
Yes, I show that Darren Patterson has represented you in the past. Is he still representing you?
No.
Your Honor.
Okay. Yes, Mr. Regier.
Forgive my interjection, Your Honor, but the state does have a recommendation in this matter based off of the previous journal entry of sentencing.
Go ahead.
Your Honor, this is a case where it does appear that the court proceeded to disposition and sentencing in December of 2020. Okay. The journal entry of misdemeanor conviction sentencing does appear to refer to a date by which the case was to be paid in full or requiring the defendant to appear in court on that same date. Based off of the state's understanding, at least as of March of 2023, there was an outstanding balance in this case. The state does respectfully submit that this matter should be sent to collections.
Yeah.
All right. So December 19th of 2022, the defendant with counsel Darren Patterson, both present via Zoom at separate locations, entered a plea agreement. The defendant pled guilty to counts 1 and 2, was found guilty of same, was sentenced on count 1 to $100 and a 90-day jail sentence with a 6-month non-reporting probation. On count 2, $63. Count 3 was dismissed. Attorney fees were waived. The court costs of $108 were imposed, and he was told to pay the total or appear for a review March 13th of 2023. Looks like he neither paid nor appeared for his review. Therefore, the court could find him in violation, but this is not the hearing we intended to do that, or I would impose Mr. Patterson as his counsel if he qualified again. The financial balance is $271. I think he paid a cash bond. Let me double check that. It looks like he posted a $271 cash bond on May 31st, 2025. And since he paid cash instead of giving that to a bondsman, I would propose as an alternative, Mr. Regier, that rather than sending it to collections, that it be paid from his cash bond and then decide whether or not to proceed with reinstatement of probation or release him. Mr. Mendoza, you don't have an attorney here, but how do you feel about what the court has just said, or do you want to talk to an attorney first?
No, I don't need to talk to one.
You want to proceed on your own behalf?
Yes,
Do you know that I can stop and have you apply for court appointed if you can't afford to hire an attorney?
yes,
And do you want to hire an attorney or apply for court appointed before we proceed further?
no,
You just want to continue on your own behalf?
yes,
All right, is anyone making you waive your right to an attorney?
no,
All right, then I'll have the record reflect that you're proceeding on your own behalf today, knowing you have the right to an attorney, but not exercising that right. On your own behalf, what do you think of the court's proposal of just paying the $271 out of your cash bond and maybe closing the case? Or transferring you to a non-reporting probation?
that sounds good to me.
All right, then Mr. Regier, how does the state feel about that?
Your Honor, on the issue of probation revocation, it would appear that, one moment, Your Honor.
I think he's here on his failure to appear for the review that was previously set rather than an actual warrant to show cause.
Your Honor, may I go off mic and off camera very briefly? I appear to be experiencing certain technical difficulties.
Yes, we'll take a brief recess for you to do that.
Thank you, Your Honor.
You're welcome.
The state is prepared to proceed, Your Honor.
All right. We are back on the record in 2022 TR 2328, State of Kansas versus Prisciliano Mendoza. All parties as before. Mr. Regier.
Your Honor, this appears to be a case where the court had previously granted the defendant a 6-month non-reporting probationary period. The state is not aware of any warrants to show cause or orders extending probation before the court. Therefore, the state does respectfully submit. It would appear the statutory time frame for such a document appears to have elapsed. As to whether or not the cash bond is to be applied in this case, it would appear that the state is not aware of any necessary paperwork being executed to that effect. Therefore, the state does maintain its position, absent a contrary finding by the court that this matter should be sent to collections.
All right. I am not going to send this to collections because I think it would complicate the defendant's ability to pay. And Mr. Mendoza, if you want that 271 cash bond applied to your balance, you'll need to go to the clerk's office and sign any necessary paperwork. And if anyone else posted that in their name as opposed to yours, such as a father, a brother, a girlfriend, they'll have to come down and sign the release of that to apply it to. But I will authorize that, and I'm going to set this on a Monday with Mr. Patterson in case for further review. Let's do, can we squeeze him in on October 29th at 8 a.m.? Destiny?
Your Honor, the 29th is a Wednesday.
Oh, okay.
And Your Honor,
27? Yes.
is the court appointing the public defender to this matter? The state understands that previously on the record, the defendant had waived his right to counsel.
He did, you're right. So no, I'm not going to. All right, I'm going to approve Mr. Mendoza's application of bond to pay his case. That will be the order. And when payment is made, I'm going to close the case. Probation completed. Is that what you want me to do, Mr. Mendoza?
Yes, how long, how much do I need to pay?
Well, stop at the clerk's office and they'll tell you the balance. What I'm seeing on the computer system is $271, which is the amount of your bond. So you may be able to just apply your bond money directly if that has not been returned to you, and it doesn't look like it has.
Okay.
So stop by the clerk's office. They'll tell you how to get that paid. And I'm going to order that you pay that right away. And if you don't get it paid, then the notice will go up to Topeka to your license. You'll probably get your license suspended. And driving without a license is a pretty big deal.
Okay, thank you.
So if you can get that signed over today, that's what I would want to see you do. But let's pull this in 1 week. Let's put this over. What's a week from today, Jen? 8/27?
It would be the 27th, Your Honor.
Let's set this over to 8/27 and make sure that you or whoever signed that bond gets it signed over to the clerk within the next week if you want to get this closed on by the 27th, on or before the 27th. Okay. And in the meantime, until the case is closed, of course, you're welcome. Now pay attention here, 1 more minute. Make sure that until this is closed, you don't violate your probation in any other way. Make sure that not only do you get it paid, but you also don't go out and violate any laws, because that could get your probation revoked. And if you didn't go out and get booked and printed as required, that could be a violation of your probation, but you're on bond, so I know you did get your picture and prints taken. So just don't go out and commit any new violation of the law between now and the time you get this case dismissed.
Okay, thank you.
You're welcome. You may go, and if you haven't paid, you need to be back here a week from today.
All right, thank you.
You're welcome. You may go. I want to review that next week to make sure he paid and to close his case.
Judge, I have Christopher Calouette, starting with a C.
Calouette. I know that name, don't I, Mr. Calouette, from years past. We are on.
Oh, a lot of years back.
A long time back, yes. On the record.
Yeah, I didn't have no gray hair back then.
You say you did or didn't?
Didn't.
Are you talking about you or me? Yeah, I didn't have it either.
Only both of us.
Yeah, we were a little younger. We're on the record in 2025 TR 1311, State of Kansas versus Christopher Lee Calouette. Jared Regier for the state, the defendant in person and pro se. Way up on the computer here. Mr. Calouette, in count 1, you're charged with driving while your license was suspended after a prior conviction for driving while suspended. That prior conviction elevates this to a Class A misdemeanor. That means your sentence could be up to 1 year in jail and your fine could be up to $2,500. Those are extremes, not necessarily what you'd get. Count 2 alleges you made an unsafe turn or stop and you failed by failing to give the proper signal. That's a traffic infraction. I believe there's a scheduled fine of $75 for that, but no jail time. The driving while suspended does allow you to either hire an attorney, or if you cannot afford one, to apply for court appointed. You can waive your right to an attorney and represent yourself. However, do you want to talk to an
Well,
attorney?
I'm gonna
before-
apply for an attorney.
All right, fill out the application. Are you employed at this time?
I just got hired on part-time at Subway in Wichita.
Part-time at the sandwich restaurant?
Yes, ma'am.
All right. And you said part-time, like 20 hours a week?
I'm not even sure yet.
Okay. All right. Any other income at this time?
No, ma'am.
Married or single?
Single.
Any children that you legally support?
Yeah, I have my two sons.
Two children?
Currently, right now, I have a $0 a month child support payment, but I have to pay $25 to my rear.
Okay.
I just got out of prison in May.
Oh, I'm sorry you went that direction. Hopefully you're coming back the other way for good.
That's what I'm working on.
Okay, I'm going to appoint Attorney Darren Patterson, but you still have to fill out your paperwork before you leave and give it to the officer.
All right. Thank you, ma'am.
You're welcome. And then you have to go across the street to Darren Patterson's office, give them all your contact information and see if there's what they can do to help you on this. And we'll be back. What day? It'll be a Monday at 8 o'clock. What day will that be, Destiny?
November 10th, Your Honor.
Okay.
It's far way out. Don't forget to see Mr. Patterson or come back to court.
I was hoping it'd be further out because I have a court date November 5th for child support in Wichita, and right now I'm in Wichita work release, so
All right, well,
that works for me.
you can do better. Make sure you do.
I'm working on it.
All right, don't forget to go see Mr. Patterson. Don't forget to leave your paperwork.
Thank you,
Okay.
ma'am.
You're welcome. You're excused at this time.
The next one up is Marshall Gaddy, last name Gaddy with a G.
We are on the record in 2025 TR 1239, State of Kansas versus Marshall Caleb Gaddy. Jared Regier for the state, Mr. Gaddy appearing in person, and pro se. This is your first appearance, Mr. Gaddy, so I'll go over your charges. You're charged with speeding 75 in a 55 mile per hour zone. That is a traffic infraction that carries a scheduled fine, but no jail time. The scheduled fine for 75 and a 55 would be $105 with 108 court costs. That's it. 75 and a 55. $105, $108 for a total of $213 on count one. And then on count two, you're charged with driving after your license had been restricted, suspended, or revoked. That charge I don't see 8245 very often, Mr. Regier. I'm gonna have to look that up for sure to tell you right.
I believe that license restriction was just corrective lenses, and I did get corrective lenses. I did not have them on that day.
Okay, that's driving with, okay, driving without restriction or driving in violation of your restrictions. I don't see that one quite as often, but let me double check that. Like I said, I want to make sure I give you the right possible penalties. Every person shall have such person's driver's license in such person's immediate possession at all times. However, no person charged with violating the section shall be convicted if you produce in court or in the office of the arresting officer a driver's license issued and is valid at the time of your arrest.
With all due respect, Your Honor, the court does appear to be referring to KSA 8244. State understands as the ticket charges count 2 under KSA 8245.
Right. The licensee may operate in compliance with the restrictions. The division determines the appropriate restrictions that are necessary to assure the safe operation of the motor vehicle. It's a misdemeanor for any person to operate a motor vehicle in any manner in violation of the restrictions imposed in a restricted driver's license issued to such person. Violation of restrictions on a permit on a first conviction shall not exceed $250, and the court shall suspend a person's privilege to operate a motor vehicle for not less than 30 days nor more than 2 years. It goes on to talk about second or subsequent convictions, but this is not charged as anything but a first. So it looks like if you're found guilty either by a plea of guilty, no contest, or at trial, you shall be given a fine up to $250, but no more than, and you shall get your license suspended for at least 30 days, but no more than 2 years. All right, so the first conviction doesn't talk about jail time, so I can't appoint an attorney to represent you, but you can hire an attorney. Do you want some time to hire an attorney, or do you wish to waive your attorney and represent yourself? Mr. Gaddy?
I will just represent myself, Your Honor.
And Your Honor,
Yes, Mr. Regier?
the court did appear to refer to certain sentencing provisions under KSA 8291. The state understands that count 2 is charged under KSA 8245 and pursuant to subsection D of the same, quote, it is a misdemeanor for any person to operate a motor vehicle in any manner in violation of the restrictions imposed in a restricted driver's license issued to such person.
But there's a specific sentencing statute in 8291 for violation of restrictions on a driver's license or permit. And when you have two statutes in contradiction, as that would appear to be, then the more specific applies, and that's why I picked 8291. Now, if we went with the statute itself that says penalties, you shall be guilty of a misdemeanor, then you shall not be fined more than $500, nor sentenced to a jail period more than 90 days, or both. But that's 90 days would still be less than the 6 months that case law talks about appointing an attorney if jail time is over 6 months, or 6 months. So I can give you time to pay an attorney if you want to go out and look for an attorney, or I can accept your waiver at this time if you want me to proceed today. Sir, how would you like to proceed, Mr. Gaddy? Do you want time to talk to an attorney, or do you want to proceed today?
I will just proceed today.
All right, well, in order for you to do that, I need to know that you understand you do have the right to go out and hire an attorney if you wish to. Do you understand that?
Yeah, I might as well do that.
All
That
right.
way I don't. It
Okay.
would just make all this easier.
All right, so let's set this over to Monday morning at 8 a.m., please, Destiny.
Yes, Your Honor, that'll be November 10th.
All right, I'm going to continue this so you can talk to an attorney to November 10th and be back here at 9 a.m. with that attorney ready to go should you choose one. If you don't wish to choose or hire an attorney after you've talked to one, then be sure and be here ready to go at that time. All right, and is there any, I don't know if there's any chance this is a divertible offense that you could talk to the county attorney about diversion. They usually want you to go and look at their website online. So
Okay.
Deputy, if you have that website, he can look at it and see about diversion too.
Okay.
So please put in the docket notes on the record, he's going to look into diversion and look into hiring an attorney. All right, and you're going to have to be back here. Are you on bond?
He needs to go get processed, Judge.
Yeah, go out and get your picture and prints taken, and I'm gonna give you a $500 cash or surety bond.
Cash or surety?
Cash or surety on $500, yes.
Ooh.
All right, if there's nothing further, we'll be in recess on Mr. Gaddy.
Do we need to take him into custody?
I don't believe so.
Okay, well, then you'll have to post his bond out at the jail of $500 cash or surety.
Right.
Okay,
Make sure you don't violate any more laws, sir, or you'll get worse problems.
Understandable. The $500, do I need to pay that?
You'll need to pay that at the jail, either in cash or have a bondsman help you post it.
Would I not have to pay that if I just continued today?
Well, I am continuing it,
Okay, understandable.
and you would have to get your picture and prints taken. Now, if we didn't continue it and we resolved it today, you'd have to get your picture and prints taken, but you wouldn't have to pay the bond, no,
Okay,
because your case would be resolved today.
I apologize. Can I just resolve it today? I understand that.
Well, I don't
That-
want you to feel pressured into giving up your right to an attorney, Mr. Gaddy.
Okay,
I'll tell you what,
Understand.
I'll make that an OR bond, deputy. Make it OR since he did come in on his summons.
okay.
I don't want to give him the impression that he has to waive his attorney today.
thank you, Your Honor.
You're welcome. Fill out an application if you, well, go hire your attorney, because like I said, I don't believe I can, with these penalties, I don't think I can appoint an attorney.
Understandable.
Okay. While you two are finishing up, there's a William Alexander. How do you pronounce that last name? Acevedo? Acevedo, how do you pronounce that, sir?
Good morning, Your Honor. Acevedo.
Say that again, please.
Acevedo.
Acevedo, okay. We're on the record in 2025 TR 1166, State of Kansas versus William Alexander Acevedo Membrano. Jared Regier for the state, the defendant in person and pro se. Mr. Acevedo, you're looking at one count of operating a vehicle without a valid license, a Class B misdemeanor. If convicted, your fine could be up to $1,000 and your sentence could be up to 6 months in jail. Are you going to hire an attorney, apply for court appointed, or waive your right to attorney and proceed on your own behalf today?
I would just like to proceed on my own behalf today, Your Honor.
So you're wanting to waive your right to attorney,
Yes,
give up your right to attorney. You don't want to go out and hire an attorney or apply for court appointed, is that right?
that's right. Yes.
All right, I'll have the record in the journal entry and the docket notes reflect you're waiving your right to counsel. And how do you want to plead to operating a motor vehicle without a valid license?
Guilty, Your Honor.
By pleading guilty, you're admitting that you did drive without a valid license on it.
Yes, Your Honor.
That was April 18th, 2025 in Butler County, Kansas.
Yes, Your Honor.
Do you remember where you were driving when the officer stopped you?
I think it was,
How about Southeast Turkey Creek 404? Does that sound right?
that sounds about right. Yes, Your Honor, because I was working on a house in Butler County then, yes.
All right. I will find that I have jurisdiction. And were you on a highway or roadway open to the public while you were driving? Is this
I
a
was
road
on
that
the, yes, I think it was on a road for the public, yes.
other people were able to drive on it, not just you?
Yes,
And it wasn't just the customer's driveway or something like that? You went out
No.
into the road? Okay. All right. Was your license suspended at the time?
No, Your Honor, I had a foreign license and the officer didn't take it. The reason was because I'm still working on my papers. I'm waiting for my papers so I can get my license from Kansas.
Where are you
And I
from?
have to wait for my, yes, I'm sorry. I apologize. I have to wait for my papers. So I have to show them proof of identification at the DMV. And that's why I haven't been able to get my license. I have tried going to the DMV to get my license, but they told me that I have to show them proof of my my status and my information.
Okay. Well, the ticket says you live in Wichita, Kansas, but are you from Mexico?
No, I'm from El Salvador, Your Honor.
El Salvador. Okay. And so DMV wants some kind of legal proof that you're entitled to a driver's license?
Yes,
Okay. And you haven't gotten those legal papers that they need to see yet?
yes, I haven't been able to get them yet. Yes,
So
but I do have a license from my country. It's a foreign license, and I showed that to the police officer, and he told me that I would just have to go to court and talk to the judge about it.
all right. Do you want to have an attorney talk to you about these issues and see if there's any legal defense with the foreign license or not?
Well, if I could, I would like to do that. I mean, he might direct me in the right direction of seeing what can I do about it. Yes.
All right. And you said, did you say you were going to work on a house in Butler County when you were stopped?
Yes, yes, that's what I was doing. Yes, Your Honor.
All right. So you were leaving Wichita, headed into Butler County to do some kind of work on a house.
Yes, I work I work on a remodeling.
Mhm.
Yes,
All right.
but that's one of the reasons why I stopped working because I didn't want to go out of Wichita to work, and I'm not longer working in Butler County anymore.
All right.
Neither
And
further.
so do you have any income at this time? What's your job now?
I'm only working like about 4 hours, Your Honor, a day at
Are
the
you
moment.
You're a self-employed contractor, is that what you said, working on projects?
Yes, Your Honor.
And what do you make per month doing that? Or a
I would
week if you
say
know?
probably, I would say like about between 300, 350, at the most 400 a week.
Well, 1,200 a month at the most.
Yes,
Okay, and are you married or single?
Mary, Your Honor.
And does your spouse work?
No, she doesn't work. As a matter of fact, she helps me when she can.
Do you have any minor children, that is children under 18 that you legally support?
Yes,
How
two.
many? Two?
Yes.
So you're a family of four, and what do you pay per month for rent or mortgage on a house payment?
For rent, I pay $600 a month, Your Honor.
You have to pay any utilities on top of that, water, trash, electric?
Yes. Everything,
much?
water, gas, trash, everything.
Do you know how much that is?
In gas, I pay like about 200. electricity, I pay like about 200 and something, and water like about $100.
All right. Any other income besides what you've mentioned?
No, Your Honor.
All right, I'm going to show that you do qualify for court-appointed attorney, and I will appoint Attorney Darren Patterson. And are you ready to write down his name and number?
Pero rápido. No, give me 1 second. They're just gonna bring me a pen right now, so I can.
Everyone
so I can
listen
write.
to me. Okay, everyone on this screen, listen to me. Never come to court without a pencil and paper ready to write. Always bring your pencil and paper every hearing. Let me know when you have yours, Mr. Acevedo.
Yes, Your Honor.
And Your Honor,
Okay, I have it ready, Your Honor.
Hey, Mr. Regier.
in the interim, the state would have it noted on the record that at the appropriate time, the state does wish to be heard on the issue of bond.
All right. Okay, Mr. Patterson is your attorney, Patterson. His phone number is 316-322-7700.
Okay.
Call him as soon as you leave this hearing. Give him your name, your contact number, and your hearing date, which Destiny is about to tell us when that will be on a Monday.
Okay.
November 10th, Your Honor.
November 10th. That's the
Okay.
10th day of November be here at 8 a.m. by Zoom.
Okay.
Mr. Patterson will have your Zoom codes for you, so make sure you get those a day or two in advance from him.
Okay, Your Honor.
And then there is the issue of bond that council wants to be heard on. Mr. Regier, go ahead.
Yes, Your Honor. While the state does acknowledge the level of and nature of the charge currently before the court, the state understands this is a defendant who was recently before this court on multiple Butler County traffic cases, 23 TR 3541 and 23 TR 3480. It would appear both those matters proceeded to disposition in August of last year, and it would appear both those matters did include multiple charges, including the charge currently before the court today. Under those circumstances, while the state is not opposed to the court authorizing an unrecognizance bond in this matter, as it would appear that the defendant has appeared pursuant to a summons, the state is recommending an amount of $4,000.
Okay, your bond is 4,000 OR. You must make an arrangement with the officers to get your picture and prints taken for this case. I'm going to let you sign your promise to appear, but it's going to have an agreement that if you don't appear at your next hearing or any future hearings, you're going to owe the state of Kansas $4,000 on a bond revocation.
Okay. So
Well,
does that mean that, do I have to pay a bond now or
no, but you have to
or
sign it. You have to sign it. Sign the bond with the promise that you're going to appear or owe $4,000. So you'll
Okay.
need to go in the breakout room when you're through here with the court security officer, set up the time to do it. If you don't go out and get it done in El Dorado when he tells you to, you're probably going to get a warrant for your arrest.
Okay, I can go as soon as I'm done with the court today.
Talk to him. He handles all of that. I don't get involved in the scheduling. He does that. So go into the breakout room. Something's going to flash up on your screen, says invitation to breakout room. Click on that. The two of you will talk privately. When you're through, call Mr. Patterson and set up a time to talk to him. And then make sure you keep the commitment to go out and get your picture and prints taken.
I will do, Your Honor.
Mr. Patterson may have some ideas on how to help you get your license. And if he does, that's certainly to your credit to get it done before the next hearing, if at all possible.
Thank you,
Anything
Your Honor.
else? You're welcome. Anything else, Mr. Regier?
No, Your Honor.
All right, Missy, I think you're administering this hearing, right?
Yes.
Could you please put William Alexander Alvacido in a breakout room with court security too?
Yes, they should all have their invites.
Thank you. Deputy Goffeld, who do you have next?
Last name Pickens, starting with P, first name Mac. Mac.
Mac Edward Pickens, okay.
Okay, Judge, he's coming slowly. Right here and take your hat off. All right.
Have a seat, Mr. Pickens. Thank you, sir. We are on the record in 2025 TR 1219, State of Kansas versus Mac Edward Pickens. Can you hear me, sir?
Can you hear?
I don't hear. I can't hear.
You can't hear anything I'm saying?
Not much. No, well. I've got her up as loud as I could do it.
No,
Judge.
I do too. All right, Mr. You are Mac Edward Pickens, is that right?
Are you Mac Edward Pickens?
Yes,
And who's helping you there with your hearing?
that's my daughter.
All right, and what is her name?
Alicia Pickens?
Thank you, Miss Pickens. All right, Mr. Pickens, you're here because the state is alleging that you were driving without liability insurance in Butler County on May 28th of 25.
Mm-hmm.
Yes, ma'am.
Okay. Now, do you want an attorney? You can hire an attorney. If you
Okay.
cannot afford to hire an attorney, you can apply and see if you qualify for a court-appointed attorney.
No.
You want to represent yourself without an attorney?
Yes, ma'am.
But you know you can have one if you want. Do you understand?
It don't matter no more than what this is. I can't see the need for it.
All right. Well, I will show that you're knowingly and voluntarily waiving your right to attorney.
Yes.
And how do you want to plead to driving without liability insurance on May 28th, 2025 in Butler County?
Yes.
You want to plead guilty?
Mhm.
You plead guilty?
What?
Guilty? You plead guilty if you admit it.
I'm
If you want to
guilty of
admit it.
what? What was I guilty of? Not having a.
The insurance?
The state is saying you were
Not
driving
having
without
the-
insurance.
The
They're
insurance on
saying
the day you were stopped.
Having insurance on the day that I was stopped.
May
No,
28th
I
of
guess I did
2025.
not.
Well,
You
you
got
can,
it the day after.
Huh?
You had it the day after.
What?
You got the insurance the day after you were stopped.
I got the insurance the day after I was stopped.
all right. Now, the county attorney has a diversion program. I don't know if you would qualify, but if you qualified and applied, you might be able to get this dismissed by paying a little extra to your fines and costs and showing you have proof of insurance now. Are you interested in that?
Yes.
Yes.
All right. Let me look at something here. Do you have a pretty good driving record? They look at the driving history.
Yes.
I just hope it.
This is the new one. Right. Is that what she was asking? No. No. What?
All right. It looks,
Driving
from what I can tell, it looks like you,
driving record? Yes. Is that what
Look-
she said?
that's what I said. It looks like you have a pretty good driving record.
Yes, ma'am, I do.
All right. So you can go talk to the county attorney or you can look online. They look for you to apply online. Miss
Okay.
Pickens, do you think you can help him go online and look up that application?
Yes, ma'am.
It's at BUCOKS, short for Butler County, Kansas.com. You may, if you can't find it, just Google diversion Butler County attorney. But they like for them to apply online. There's an application fee. And then he should get, if he's approved, he should get a packet in the mail shortly thereafter to fill out and send in with the payment. They pay to apply and they pay to accept. I don't know how much it is, but maybe they say online, but most people like to do that instead of having it stay on their record and affect their record and their insurance and so forth.
Okay.
But he will have to show he's got current proof of insurance. And the state of Kansas may make him file a document for a while called an SR-22. So make sure his driver's license has his correct address. They only send it to the last known address.
All right.
Okay. All right, so
Okay.
let me give him a new court date, and let's make that what date? Let's put it on a, oh, is he going to apply for an attorney also?
You said no attorney?
What?
You said no attorney?
No attorney.
All right, deputy, have him sign the waiver. And Destiny, what date does he come back?
I've got Wednesday, November 19th at 9 a.m.
Let's do November 19th at 9 a.m. Ms. Pickens, he can either come back to the courthouse or he can do that online if you want to help him do it online by Zoom.
Okay.
And
right.
if you don't get the codes from the clerk a day or two before the hearing, call the clerk of the district court and she can tell you the Zoom codes if he doesn't want to come in person.
Okay.
But if he gets diversion, he may not have to come back. They may divert him so he doesn't have to.
Okay.
All right. Well, thank you for helping Miss Pickens. And Mr. Pickens, you're excused at this time, although you need to go get your picture and prints taken.
All right.
You need to
Let's
read
give
that.
him 1,000 OR. 1,000 OR, deputy.
Okay.
Mr. Regier, anything further?
No, Your Honor.
All right, we'll be in recess. Thank you. Mr. Pickens is excused from these proceedings.
Okay.
All right.
Okay. There you go. That's it. That's it.
That's it for here.
Okay. Have a good day. Next one up I have is Brian Johnson. Okay. I'm glad to go. Thank you, sir. See ya. Brian.
We are on the record in case number 2025 TR 1173, State of Kansas versus Brian C. Johnson. Jared Regier for the state. Sir, you are Brian C. Johnson, is that correct?
Yes, ma'am.
Thank you, Mr. Johnson, appearing in person and pro se. Mr. Johnson, you're here on one count of operating a motor vehicle without registration or with an expired tag, an unclassified misdemeanor. Penalties could be up to $2,500 fine. That's the maximum. They're usually much, much less. And it could have a 30-day to 6-month jail sentence, but probation is certainly an option and usually granted. You could go look at the county attorney's diversion program I just talked to the other gentleman about, where you pay extra for fines and costs and show proof of registration currently and maybe get it dismissed. Or you have the right to an attorney. You can hire an attorney, apply for court appointed, or waive your right and represent yourself. You wish to talk to an attorney, Mr. Johnson, before we go any further?
No, no, ma'am.
You want to waive your right to an attorney, even though you understand you do have one?
Correct. Yes.
All right. You don't want to hire or apply for court appointed?
No, ma'am.
All right. I'll have the record show that you're knowingly and voluntarily waiving your right to attorney. Do you want to look into the diversion or enter a plea today? You can plead guilty, admitting the charge, and we proceed to sentencing. You can plead not guilty, and we'll set this for trial at a later date. Or you can plead no contest, which means you don't want to admit the charge, but you don't want to deny it and set it for trial. So how do you wish to plead, sir, or proceed?
Can I speak to somebody about the diversion? Because I emailed all the registration and stuff over the day after I got pulled over. So.
Well, the person you talk to would be the county attorney's diversion officer. And you can do that probably by going down to their office and following the receptionist's directions. But in the meantime, I need to know what you're going to do if you don't get diversion.
No contest.
Okay, why don't we set this over? Can we do 11? Is that 11/19 a Monday or a Wednesday, Destiny?
11/19 is a Wednesday, Your Honor.
How about if we put him on that date, 11/19 at 9 a.m.?
Yes, ma'am.
Okay, Mr. Johnson, you'll need to be back here 11/19, that is November 19th at 9 a.m. And if you want to do a no contest, you can do it at that time. That'll also give you the opportunity to talk to attorney about your options. That'll also give you time to talk to the county attorney and maybe have it diverted by then.
Okay.
All right, and then let's see, do we need to have his picture and prints?
No,
We don't, he's already done that. He's on bond. I'm not seeing a bond.
None of that. I didn't get arrested or anything.
oh, well, then
You're on
maybe
a summons.
Your Honor, if I may.
Mr. Regier?
registration.
Your Honor, pursuant to the
Oh.
information, this is a case that appears to involve one alleged unclassified misdemeanor.
It's not an A or B misdemeanor, so no, he does not have to get his picture and prints taken. He may have already done that, and that so be it. But if he didn't get arrested, I'm not gonna make him go out and do it now. All right, you may go check on that diversion and anything else you want, just as long as you're ready to go November 19th at 9 a.m.
All right, thank you, ma'am.
You're welcome.
Okay, next one I have is last name Thomas. Shauna Thomas.
How do you pronounce that first name?
Shayna.
Dana? On the record in 2025 TR 1212, State of Kansas versus Shayna Jashwan Thomas. Jared Regier for the state. Ms. Thomas appears in person and pro se. This is Ms. Thomas, your first appearance. I will go over your charges and count one. You're charged with speeding 69 miles per hour in a 60-mile-per-hour zone. This is a traffic infraction. It carries a fine, but no jail time. If you were to be convicted by plea or trial, the fine is scheduled at $45 and your court costs are $108. And then on count two, you're charged with driving while suspended. That is a misdemeanor. It is a class B misdemeanor. It carries a fine anywhere from $100 to $1,000 and up to 6 months possible jail sentence, although probation is an option on the first conviction. On a second conviction, you'd have to actually serve 5 days in jail up to 6 months or a year, up to a year. So at this time, do you wish to hire an attorney or apply for court appointed or waive your right and represent yourself?
Court appointed.
All right, you'll need to fill out an application and leave it with the officer. Are you employed at this time?
Yes.
Where do you work?
Quick shot.
Where? Quick Shop?
Shop.
Okay, and what do they pay you per month at Quick Shop?
Per month, maybe 800.
Are you married or single?
Married.
Does your spouse work?
Yes.
What kind of work does your spouse do?
Home remodeling.
Self-employed or have a boss?
Yes, he has a boss.
And what does he get paid per month?
Per month, probably 4,000.
Okay, so about 4,800 a month between the two of you. And what do you pay together for rent or a house payment?
For rent, it's 2,500.
Do you have minor children that either of you supports or both of you? How many?
I have 3 sons.
So it's a family of 5?
Yes.
Okay, and do you pay utilities on top of the house or mortgage payment? Or
Yes.
rent payment? How much?
Utilities are probably up to 550.
And any other bills that you have to pay regularly? Credit card payments, bank payments, automobile payments, how much?
Credit card payments are about $250 a month.
Okay, anything else?
No, not that I can think of.
And then you have to pay food, utilities and things like that for everybody to survive.
Yes.
All right, I'm going to,
Insurance, I'm sorry.
what's that?
My insurance as well.
Okay, how much is the insurance?
My insurance is $85 a month.
Okay, and is that for house, car, health?
That is for my house. My car insurance is $120 a month.
120 for the car, how much for the house?
It's $85 because it's a package with the.
Okay, and then do you have to pay health or does that come out of what you've already given me?
Health insurance is actually $90.
Okay. All right, I'm going to, for the family of 5, I'm going to appoint Attorney Darren Patterson. And the officer can give you his address. He's right across the street from the courthouse parking lot. Go over there right after court and give him your contact information, your case number, and your court date, which is which Monday, Destiny?
November 10th, Your Honor.
You'll need to be back here November 10th. He usually likes you about 8 a.m. And that's Darren Patterson, and he can tell you if he wants you to come any later, but that's usually when he wants you here. And he can probably help you with that driver's license to get it in a little better position for the next court hearing if you see him soon enough.
Okay. I was actually in the process, it was in the process of reinstatement. I didn't know it wasn't already reinstated. It was going to be reinstated the next week. And then this happened.
Talk to Mr. Patterson. He's got a lot of experience with that.
Okay.
All right. Gonna have to get your picture and prints taken, set up at $1,000 OR bond. You won't have to put that money up unless you don't come back to court.
Okay.
And Your Honor.
Yes.
Count 2, I believe, currently reads as an unclassified or a C misdemeanor. I'll need an amended information. It was put in that way on the ticket.
Yes, thank you. Mr. McGeer, we need Cat 2 to show as a B misdemeanor.
I'll put a note in the file, Your Honor.
Thank you. All right, anything further from either party? Hearing none, Ms. Thomas is excused from these proceedings, but don't forget to get your appointment with the jail and Mr. Patterson.
Okay. Thank you.
You're welcome. Thank you.
Okay, next up, the last name is Seipel, Seipel, first name Benjamin.
All right. Yeah. We are on the record in BU 2025 TR 1548, State of Kansas versus Benjamin J. Seipel. Jared Regier for the state. Sir, are you Benjamin J. Seipel?
Yes, Your Honor.
Very well, sir. You're charged in count 1 with driving under the influence of alcohol, drugs, or both, a combination thereof. This is a B misdemeanor. Your penalties could be $750 in fines up to 1,000, and your jail sentence could be 48 hours up to 6 months. On count 2, transporting an open container is an unclassified misdemeanor. The fine could be up to $200. You could lose your driver's license for 30 days. Minimum. Count 3 is speeding 82 and a 55. That is a traffic infraction. It doesn't carry jail time, but it does have a scheduled fine if you were to be convicted either by your plea or by trial. The sentence for 82 and a 55 would be $168. Court costs $108 for a total due on that count alone of $276. You do have the right to an attorney. Do you intend to hire an attorney, apply for court appointed, or waive your right to attorney?
Your Honor, I was wanting to get a diversion, but
That is something you'll have to look into. Did you go online and look at diversion to see what the county attorney requires?
yes, Your Honor.
And did you apply?
Yes, Your Honor.
Did they grant it or deny it?
I have not gotten anything back yet.
All right. How long ago did you apply?
2 weeks ago.
All right. Well, I'm kind of surprised you haven't heard by now, but you'll need to contact the county attorney. Their office is just down the hall, or their phone number is 316-321-6999. Follow up on that. If they grant that, you'll need to sign a contract and return it with a payment before your next court date. So you're not going to hire or apply for court-appointed attorney, is that right?
Yes, sir.
Okay. Well, you can represent yourself if you want, but if you're denied diversion and decide you want an attorney, be sure to come get a court-appointed application and fill it out and return it to the court as soon as possible. Don't wait till your next hearing date. When is his next hearing date, Destiny?
Your Honor, I have Wednesday, November 19th at 9 a.m.
All right. You'll need to be back here November 19th, 2025 at 9 a.m. unless you are diverted, and the county attorney will let you know if you're diverted. But if they don't tell you you're diverted, and if they don't tell you that you can skip court, you better be here or you'll get a warrant. So November 19th, 9 a.m. is your next court date. Check with the county attorney and find out if you're getting diversion or not. Get an application and get it back to me if you decide you need a court-appointed attorney. Otherwise, you're welcome to hire any attorney of your choice. I will continue the $2,000 surety bond you posted, your OR bond you posted, May 31st to 2025, with the added condition that you be nowhere near alcohol or illegal drugs. Don't take them, don't hold on to them, don't possess them, don't consume them, don't be around anybody that has them available, and follow all laws, and be back here at that date and time I gave you to be compliant with your bond and not lose any of the money you posted on it. And
Yes,
not
ma'am.
get a warrant and go to jail. That's the big thing. Okay, anything further? Now, we had received a note from your dad that he wanted to be present with you because you had just turned 18. Is your dad there with you?
It's the uncle, not the dad.
All right. And what's your name, sir?
My name's John Schott,
How do you spell the last name? S-H-O-T?
Schott.
And you're his uncle? All right. We'll make a note that you were here with him.
And Your Honor, we had applied for a court-appointed attorney.
Okay.
Um,
Let me see if I have that application in the file. Well, I'm not seeing the application in the file. Are you seeing it, Destiny?
Yes, Your Honor, I saw it on July 9th is when it was filed.
All right, thank you. I do see that now. And it looks like I did approve it. Just didn't name the attorney. Mr. Benjamin Seipel, are you still a student? Or did you graduate?
I graduated.
And you're not working, is that right?
I am working.
Is that at an animal clinic?
Not anymore, no. I am doing a remodel with Walmart right now.
So are you working for Walmart or a contractor?
Working for Walmart. And it's supposed to last till October. But there's a chance that I could get it for longer.
Well, it looks like maybe you need to update your application then, because when you turned in this application June 17th, you were a high school student intern, it said, working for Cheney Animal Clinic. And you've changed that since then?
Yes, Your Honor.
And they weren't apparently paying you as an intern?
No, they were paying me. I was getting paid.
Deputy, why don't you give him an application and put in big letters, updated? How much are you getting paid to do that work at Walmart per month?
$15.50.
$15.50 being $1,550 a month?
no, $15.50 an hour, Your Honor.
Yeah.
Oh, an hour. Okay, yeah, have him fill that out as an update.
Okay,
And then call back later in the week to find out if you're appointed and who you have. All right.
Who do we call, Your Honor?
Call the clerk of the district court, and what number would he call, Destiny, for that?
Just our main line, Your Honor, so the 316-322-4370.
Okay.
Are you going back to school in the fall at all?
I'm not too sure. I'm still thinking about it.
College or a trade school, maybe? Okay.
Yeah.
Yeah, there are a lot of options out there besides traditional college too. All right, thank you, Mr. Seipel. You're excused at this time. Let's make him get his, he's probably already been bonded, so I'll continue that bond. Your bond is continued again that you have no alcohol or illegal drugs. Stay away from where it's located, including parties, liquor stores, bars, and those kinds of places. No alcohol or illegal drugs while you're on this bond. And reappear November 19th, 2025 at 9 a.m. And call back and find out who your attorney is later this week if you have one. If not, you're going to have to hire one or represent yourself if you don't qualify.
Okay, or if he gets a diversion, then he would necessarily need an attorney, right?
Well, that would be up to him. You might want an attorney to help him understand what that diversion means and what the consequences are if he violates it or gets in trouble again for this. Because DUI diversion is a little bit different than some of the other forms of diversion. But that's up to him whether he gets an attorney and or diversion.
Okay.
All right, thank you. You're excused
Thank
at
you.
this time. You're welcome.
Thank you, Your Honor.
You're welcome.
Okay, next one up I have is Patrick Schaefer.
All right, bring him in.
Patrick.
All right, we're on the record in case number BU 2025 TR 1309, State of Kansas versus Patrick James Shaver. Jared Regier for the state. Sir, you're James or Patrick James Shaver, is that correct?
Yes, ma'am.
Thank you, sir. The defendant appears in person and pro se. Mr. Shaver, you are here on one count of driving while suspended after a prior conviction for the same. The prior conviction elevates this to a Class A misdemeanor. If convicted, you could have a fine up to $2,500 and a jail sentence up to 1 year, although probation is an option, usually after 5 days served. Do you want to hire an attorney, apply for court appointed, or represent yourself?
Apply for court appointment.
All right, fill out an application, give it back to the officer before you leave, and then call later to the clerk's office this week and find out if you have an attorney and who it is, then contact that attorney before your next court date. And
ma'am.
Destiny, his next court date is?
On a Monday, Your Honor,
Yes, please.
Monday, November 10th at 9 a.m.
You must be back here November 10th at 9 a.m. And you must contact your attorney if one is court appointed before then. If you hire one, make sure you have that attorney hired and ready to go for that hearing.
Okay.
I will continue the bond that you have posted with those added conditions. Anything else we need to address on this matter, Mr. Regier?
One moment, Your Honor.
Is this, will this be Zoom too, or will it be?
Yes, it will be by Zoom, and you can appear either in the courthouse or by Zoom. If you have an attorney, the attorney will get the Zoom codes. If you
Okay.
do not have an attorney, make sure the clerk has an email for you before you leave today.
Yes,
If the
ma'am.
clerk has your email and hasn't sent you the Zoom codes within a day or two of court, be sure and call and get them. You don't want to miss by Zoom or in person.
Yes,
And
ma'am.
And also, if you need a ride, you better let Butler County Bail Bonding know so they get you here. Otherwise, you'll owe them, you'll cost them $500.
Oh, yeah, I know.
Okay.
Your Honor,
All
the state does have one final oral motion to make before the court in this matter.
Go ahead.
Your Honor, the state is seeking an additional condition of the bond in this matter, specifically that the court authorize GPS monitoring or that the defendant be ordered to appear in the alternative in person for all future proceedings. This is defendant who has a history of multiple cases in the Butler County court system, including 22 CR 301. In that matter, it would appear that proceeded to disposition in May of 2023. In that matter, I am showing at least 3 prior failures to appear, including at least 1 pretrial setting, Your Honor.
Your Honor, I ain't had no failure to appear. So, I've made it to all my court dates. That 2022, my lawyer kept postponing it so that we could get things straightened out because they had my couple journal entries not right, That's why it kept going on for so long. And my lawyer was Watts, James Watts.
Mr. Watts usually takes felony appointments only. So were you looking at a felony originally?
Originally, I think it was a felony. It was a possession of hallucinogenics or whatever. And they were trying to say that it was my third or more, and which it wasn't. It was on my first one, And so, yeah.
So he got pled down to a misdemeanor, Mr. Watts did?
Yes, ma'am.
All right.
Well,
Well,
I was in court when I was supposed to be, or in the Zoom when I was supposed to be.
all right. Well, Mr. Shaver, it looks like you have pending right now a case in
I've got
Raleigh County, Wellington, maybe.
no, ma'am.
You don't have something going
I just
on?
got out of the penitentiary like 4 months ago. I'm
Well,
on parole.
I show CLW, which I think is abbreviation for Cali Wellington. I may be wrong. That's 2024 LM 804. Then I have a BU 2025 TR 1309, driving while suspended second. And that's the case we're on today. That's pending. I have a 2024 a limited matter, that's not a criminal. 2023 state of Kansas looks criminal. Liability insurance driving while suspended second. That has a disposition date of October 24. That is the one that Mr. Regier was referencing. You referenced 22 CR 3.
I was in prison, ma'am.
Well, according to this, sentence October 7th. We do Zoom hearings from DOC prison.
Yeah, because I went to prison, so I didn't make it to that court date. And then instead of doing the Zoom thing, they put a warrant out through Butler County. So I had to sit there and I had to come back on a case where I got shot at. That's when they brought that warrant up and then put me in front of the judge or whatever. And they they worked it all. We worked it all out,
Well, I show that October 7th of 2024, you appeared before me and you were convicted and sentenced. And you had your sentence run concurrent with a Harvey County matter, driving while suspended. Second was the charge you had in front of me. And then there was, okay, now is that the 23 or the 24? Okay, let me back up. 25 TR 1309, today's case. Then there was a 24 limited. Then there was a 23 traffic before me that I was talking about that we ended up sentencing, running it concurrent to Harvey County, a 20 case they had on you. And that was a guilty plea in that 23 case. Then in 22, you had a Butler County case for criminal trespass, and
that's the one he said I missed the court for.
the 22 one, well, he may have meant
Yes,
something
ma'am.
else. But that was possession of a depressant and criminal trespass.
Yeah.
And then there was a 21 CR for possession of opiate, opium, narcotic, or certain stimulant. 20 TR driving while habitual, driving while suspended second. And then there was a 2020 limited, a 2020 CR for possession again of opiate, opium, narcotic, a certain stimulant, as well as possession with intent to use drug paraphernalia. And then there was a 2020, I'm not sure what that is, event. I'm not sure what that is. 2020 CR 291. Your history just keeps going back a long ways.
Ma'am, a lot of them I've never, it's got to be a mistake because I've Yeah, they would have locked me up. They would have locked me up on parole because I got out of prison last time or time before this, 2019. And I did good. I wasn't even in Kansas most of the time from 2019 to 2022. I was working on the road. So, and then
Well, here's a 2003 traffic. Unlawful acts, failure to wear a seatbelt, driving while habitual violator. And then in 2006, there's a theft, 2006 ag assault, depressants.
I've already, yeah, I've already,
2007.
that I was young and I've grown up a lot.
Okay, well, you've got a wide variety of charges and convictions since that period of time.
Okay, yeah.
If you think some of these aren't you, you might want to talk to your attorney.
Yeah, I'm going to.
Okay, so were you applying for attorney or hiring
Yes, ma'am.
attorneys?
Yes, ma'am. I'm going to apply for them.
Okay, where do you work? You said you just got out of DLC when?
While I was in work release the last year of my DLC time, I work at All Metal Recycling. I'm a second shift maintenance man.
All right, and what do you get paid at the recycling for per month?
Per month. Well, after they do all my garnishments and everything, I make about $1,200 a month.
Married or single?
Single.
Children?
Yeah, I got two.
Are they-
One's 24 and one's 16.
Do you support the 16-year-old?
Yes, ma'am.
And you said you're single and you support one child, so it's a family of two. And how much do you pay in rent or mortgage?
My rent's only $325 a month.
$1,200 a month, $325 in rent.
My electric's anywhere from 60 to 150. This month's 150 because of the AC running. But
Any other payments besides those?
my water bill's 70 a month. Butler and Associates and Holland McVeigh, they garnish almost 25%, if not more, of my check every.
Okay, Butler and Associates, that's probably collections on a court case, or is that something civil?
Collections on the court case.
How much do they get each month?
Probably 1,200.
Does that make you go in the negative each month? You're not making as much as you pay out?
I do little side jobs every now and then, when I need money, like I'll do a remodeling job, on the weekend to make ends meet.
All right. Well, I want you to fill out a written application for court-appointed attorney. It sounds like you'll probably qualify. And if you do, I'll appoint Darren Patterson. And you'll need to be back here with him November 10th at 9 a.m. I think you said, Destiny.
That's correct, Your Honor.
But get that application in and call back and confirm that he is your attorney before you go see him. Once you know it's him, get over there right away, though.
8 a.m. Okay. Yes, ma'am, I will.
All right. Anything else we need to take up on Mr. Shaver's case?
Okay.
Do you have any questions?
Yeah.
You do have questions?
No, I do not.
Okay. All right. Mr. Regier, anything further?
No, Your Honor.
All right. Then Ms. Fleeman is excused at this time. Let's take up Cheryl May Earl. I've been watching her sit here patiently for a long time. On the record in BU 2025 TR 1216, State of Kansas versus Cheryl May Earl, Jared Regier for the state. The defendant, Cheryl May Earl, appears in person and pro se. You are Cheryl May Earl, is that correct?
Yes, Your Honor.
Thank you. This is your first appearance on one count of driving without liability insurance, Miss Earl. As you probably heard all morning, this is a B misdemeanor. The penalties include a fine of anywhere from $300 to $1,000, and a possible sentence up to 6 months, although you will probably get the lower end of the payment with probation, and that would be most likely a non-reporting probation. You do have the right to hire an attorney, apply for court appointed, or waive your right to attorney and represent yourself. You also have the opportunity to apply for the county attorney's diversion if you want to pay a little extra in diversion fees and maybe get this dismissed and kept off your record. How do you want to proceed, Ms. Earl?
I had a question about the diversion.
Okay, go ahead, ask it.
So if I were to take the diversion and then present them with proof of insurance, I haven't been insured lately. My boyfriend's been taking me to and from work and doing all of that. So would I need to then just get insured between now and then? Could I still apply, would the diversion still work, or would it need proof of past insurance? Does that make sense?
It does. I think they just want current insurance. But if you go on their website, it'll tell you what they require. And that website is short for Butler County, Kansas, bucoks.com. Again, that's bucoks.com. And look for the diversion, county attorney diversion. If you can't find it when you look under bucoks.com, Google Butler County Attorney Diversion. If all else fails, you can call them at 316-321-6999 and talk to their diversion coordinator.
Okay.
But you have to first apply.
I think I will go ahead and. I'm sorry, go ahead, Your Honor.
Well, you first have to apply, and then if you don't get something in the mail from them, either denying it or agreeing to it and with the contract for you to sign and return, if that doesn't show up in a few weeks in your mail, you better be calling and find out whether they accept it or reject it. And if they reject it,
I do think.
Okay, go ahead.
I'm so sorry, Your Honor. I do think I will go ahead and represent myself today just to avoid any further complication.
All right. Is anyone making you give up your right to an attorney?
No, Your Honor.
You understand you can hire any attorney of your choice, and if you cannot afford an attorney, you can apply and see if you qualify for court appointed?
Yes, Your Honor.
But you wish to give up your right at this time and represent yourself?
Yes.
Okay, now you can, I will have the record reflect you've knowingly and voluntarily waived your right to an attorney, but you can always reinstate your right to an attorney. You can always hire an attorney or apply for court appointed. If you don't get the diversion in a reasonable period of time and you decide you want to apply, contact the court, get that application back to me as soon as possible so I can get the attorney appointed and you don't have to wait and come in here without an attorney, not knowing what you're doing or the attorney knowing what he or she is doing. Let's get that taken care of. Don't wait till court. All right. When is her court date, Destiny?
Your Honor, November 19th.
November 19th. And let's put you at 9 a.m., Miss May. Or Miss Earl. Okay, November 19th.
That was 9 a.m., Your Honor.
Yes, and you could be diverted by them. You wouldn't even have to reappear.
Okay, I understand.
Okay, anything further, Mr. Regier?
Your Honor, the state's records appear to suggest this is a defendant who appears pursuant to a summons.
Excuse me, I see that too. So, Miss Earl, you are going to have to make arrangements to get your picture and prints taken and post a bond. I'll make it an OR. Let's make that 1,000 OR. Which means you're going to have to go into the security, go into a breakout room with security, and they'll set up a time for you to find your way to El Dorado and do that.
Yes, ma'am.
Anything further, Miss Earl?
No, Your Honor.
All right, then look for that breakout room and get that set up and make sure you look for diversion and get that started as soon as possible. So if you need an attorney, you can get one.
Yes, ma'am. Thank you so much.
You're welcome. Okay, Miss, if you would please put them in a breakout room. Jean D. Blount on the